of Imo State. He stated that their mode of operation is that they move in group in Siena and others confiscated vehicles, and from there they launch attack on security operatives. They also set up checkpoints where they hijack other vehicles in good working condition. The group also engage in activities aimed at terrorizing their community. That this group is so brazen that they even write to traditional rulers, informing them of their intention to attack them. They attack even in broad daylight, kill people, burn down palaces and properties. PW4 continues its evidence by stating that the IPOB group are even more brazen in their attack on police stations like the one at Njamba local government area of Imo State, that they raided the station, killed everyone there, and turned it to their base. Similarly, the police station in Umoma in Oru East local government area of Imo State was sacked in the same way, and that the group even attacked a police headquarters where they shouted away arms and ammunition from the armory and burned down the place. He stated that on the 30th day of May 2021, the defendant had ordered a seat at home in Southeast, but the late Ahmad Gulad was unfortunate, caught in the storm as he was trying to catch flight out of Owerri that day. PW4 said he was the first to get to the scene of that attack where he found the disease in a pool of his blood. He was informed by the divisional police officer in the area that the disease was in a taxi heading for the airport when the iPod and Eastern Security Network armed combatants identified him as one of their checkpoints and opened fire on him.
My work is easy because I use ClickUp. Here's how I keep track of all my tasks. I start by brain dumping everything I need to get done in a list view. Next, I set a priority and a due date to keep things.
What you're listening to is I hope you can hear me. What you're listening to is the judgment being delivered by Justice Omotosho. Before now, Nnamdi Kanu has stated his position, and the defendant is now reading out their position as well. One thing is very clear. Today, we will be having the decision by the court today.
Defendant used the said.
So we are picking back on the channels TV, and also while the defendant is reading what it's actually doing, let us, for refreshers here, we've
federal government
we've watched it before, but let's probably we're going to bring you shortly the position of Mazen
under cross-examination.
In his position, he actually maintains that there is no way
he did not sign any of the investigation reports, and also that the transmitter came in the country through the Tinkan port in Lagos. He said he did not find out the date the transmitter came into the country, as same was smuggled into the country, and that it was not part of his schedule to find out the date. That there are no records to show it came in through Lagos, save for the statement of the defendant that it came through the Lagos port. It also stated that IPOB was formed outside Nigeria and that Radio Biafra was operated outside Nigeria but broadcast within the territory of Nigeria as it was an online platform. He further stated that the defendant was arrested in Lagos with his broadcasting equipment. He said it is not the duty of the DSS to find out if Radio Biafra was registered in London. PW4 stated that he and one of the officers were sent to Ugulu
35(4) and 36(12) of the Constitution of the Federal Republic of Nigeria, 1999, amended. Sections 158, 162, and 165 of the Administration of Criminal Justice Act 2015.
So just for clarity here, what you are watching now is the position as posited by Nnamdi Kanu. So we'll still go back to bring you the continuation of that judgment. The judgment is not being given. You know, I foresee this. There is a reason why. I mean, for those of you that may be confused, because this is a very high-profile case, because this is something that has the capacity to trigger some ethnic emotion. So what the government has done is to allow live broadcast from the court. Recall that during the last presidential election, the day the judgment was delivered, we stood we stood for so many hours. I was standing for over 10 hours just for the judgment to be delivered. Over 10 hours standing on your feet. You went back home, the feet was really shaking. So I would play for you now, courtesy of TVC, what the position that was stated by Nnamdi Kanu when he was called upon. Like I said, his position centered mostly on the argument that the court lacked jurisdiction to try him. Have a listen.
35(4) and 36(12) of the Constitution of the Federal Republic of Nigeria, 1999, as amended, sections 158, 162, and 165 of the Administration of Criminal Justice Act 2015, and under the inherent jurisdiction of this very noble court, I am praying, my Lord, for an order admitting me on bail, the defendant applicant to bail on liberal terms, pending the determination of the invalid charge presently before this court, and order, my Lord, declaring that the continued detention of the defendant applicant, my humble self, in the absence of a valid subsisting charge under a written law in force, is unconstitutional, null, and void, my Lord, and for any other orders that my noble Lord may deem fit to make under the circumstance. This is supported by an affidavit of 9 paragraphs deposed to by Prince Emmanuel Kanu, and also by a written address which I urge, my Lord,
Hi, my name is Elise, and
So again, we will continue, but what you're basically looking at there is Kanu's position. And like I said before, he argued forcefully that the court lacked jurisdiction to try him on this matter. Now, irrespective of which way this court case today goes, we will, by 6 p.m. Nigerian time, 5 o'clock UK, and 12 o'clock Washington, D.C. today, we will be having some legal experts. Hopefully, some of his lawyers would, that we have invited, hopefully they will join. We'll have some legal experts give their analysis as to what to expect next, irrespective. I mean, legal experts are divided. Some are arguing that he should walk free, while some are still maintaining that a political solution is the best at this point. There are also school of thought who are saying, no, there should be punishment, and no one knows how this case is going to go today. That's why the court has decided, irrespective of how it goes today, that there should be a live stream of this case in order to show Nigerians that how things were done, not a hearsay. So let's continue with Nnamdi Kanu's presentation.
to accept its adoption. Honorable Lord.
Yes. You move the 3 applications?
I have, my Lord.
Thank you.
Thank you.
The prosecuting counsel, can you refer to those 3 applications?
May please, Your Lordship. The prosecution filed
reply to the first motion on the 14th of November 2025. We also filed a reply, a counter affidavit and a reply in respect of the first motion. For the second motion, we also filed a reply all on the 14th of November 2025. For the third one, for the further application for bail, we did not file any counter affidavit. So for the first one, sir, I respectfully adopt the counter affidavit of the prosecution and the written address. And we urge your lordship to dismiss the application because it's a regurgitation or repetition of the well-worn argument that the counts which the defendant pleaded to were unknown to law. It is for your lordship to determine that in other ones. Well, the one asking for stay of proceedings, my lord, our argument is to the fact that the statute does not permit your lordship to grant any stay of proceedings or injunction. So we urge your lordship to dismiss it. And for the second, we also filed a written address dated 14/11. We adopt it with all respect, and we urge your lordship to dismiss the application as lacking in merit. For the last application, asking for the defendant to be admitted to bail on the same ground that, the counts to which he pleaded not guilty were unknown to law. Again, is a repetition of the old argument. It is for lordship to determine whether the laws were valid, whether his plea was valid, and whether he is answerable to the law when he committed the terrorism acts. The terrorism acts he committed was...
Please,
So we urge your lordship to dismiss the application. On the other ground is also to the fact that the applicant has another pending motion filed in March, in April 2025, asking for the same relief, bail. So the latter application with respect, is an abuse. In any event, none of them merits. We urge your lordship to dismiss it.
Please, let's save the time of the court.
We are praying your lordship to dismiss all the applications because they lack in merit and do not deserve any consideration at all. Thank you, my lord.
Thank you. Defendants, you have one or two words to say?
So now, for those of you who may not have quickly picked what happened here, the defendant made his case. That's the the defendant, that's Nnamdi Kanu here, made his case and submitted that bail be granted, and he submitted that bail be granted, and also the lack of jurisdiction. Now, the prosecutor here is arguing that part of what he has already posited were repetitive, and that most of this point is left for his lordship, that is Justice Omotosho, to decide. And in this case, obviously, at this point, Nnamdi Kanu is left to have his own position as to piggyback to what
I'm most grateful.
What has been said here. So he's going to make his position known now.
My point is a very simple one, my lord. Very, very simple. My charge sheet, as presently constituted, does not reveal or disclose any written law in Nigeria as at this very morning.
Thank you.
It doesn't exist, my lord. And very finally, I think it is very, very important that I allude to what my lords
Please, defendants, at this point, you won't go and make references. I just ask you to reply on point of law.
It is, my lord. I'm trying to explain exactly what the point of law is all about. We respect what you have just said.
Yes, let me hear the point of law.
At this point, I think many would have argued that at this point, the services of a senior legal mind probably would have been the best thing to trash out. This would have been son versus son. I mean, I wish the elderly son that led his case, at that point, I think Agabi. I wish Agabi was here because he would have really enjoyed the issue of law where he piggies back to that. But anyway, he made the choice to defend himself. So let's hear what he has to say at this point.
My lord, I cite Eze the...
I'm coming. Consultants, you may guide him properly. Thank you. Let the consultant sit with his client. Or do we have all the consultants? Do they want to sit with their clients? Okay, let me see. Are you here? Mandela, you're here. Opara is okay. Where are the others? Ejiofor, where are the others?
So you can see this is Barrister Aloy Ejimako and Maxwell Opara. Now you can hear what the judge said. The judge no longer referred to him as his lawyers. In this case, they are now acting as his consultants. So it was even the judge that said, because he's trying to prompt up, because if not, this is what his own senior lawyers, a son, not even a barrister like Ejimako, but a son ought to be doing. But in this case, the judge was just being forthright to say, before you go further, can you consult with your consultant? And he even went further to say, if you don't mind, you can go and sit around him so that, even if he's sitting down, you can keep whispering something to him as to the best way to handle this. I can't repeat that enough. One would have wished that, this is being done by someone like Agabi SAN. One of the best legal minds anyway. But the decision that he defends himself is his. I hope and pray that it plays out, honestly, fingers crossed. I hope and pray that it plays out perfectly for him, that strategy. There must be a reason why such strategy was adopted.
Yes, you just have 2 minutes for this.
Okay, so obviously this is live, so pay attention. There are bound to be adverts. That's how people make money. So while that advert plays, we would come back again. Like I said, one cannot at this point. Basically, the deed is done. We are waiting for the judgment. We are still monitoring the NTA, the TVC, the judgment is still ongoing. They are still reading. That's likely to be a very, very long one, indeed, if you ask me. It's likely to be a very long one. The only thing that comes to mind is the 2023 presidential election, the first time such was transmitted. And I believe this is the second time. Before they come back, like I said, what I say this is because this case today is a very sensitive one that would have to define certain things moving forward in Nigeria. Hence, the court is trying to play safe
once again,
by saying that this
I will start with the bail application that I made. Since he did not file any counter affidavit, my lord, he is in effect conceding. and I expect that this very application should be determined based on the affidavit that I filed.
Now, see, Jimako has explained to him now that he did not file counter affidavit, which the prosecutor was actually alluding to, that these things are not orally done, that these things should be filed. So at this point, I don't know if, anyway, I don't know who to blame now. Is it that because his lawyers were fired that they didn't file that, or that he fired himself? I don't know.
And on the issue of stay, my lord, once a matter borders on jurisdiction, stay can be granted. Once it is a judicial matter, stay can be granted. What I'm asking for is for a referral, my lord, to the appeal court for the determination of these very key issues. And also, I reiterate that Abuja is not superior. It is not superior to the Constitution of this very country, and an established jurisprudence as determined by the Supreme Court that stays can be invoked insofar as the issue borders on jurisdiction. And my lord, this is very, very critical. Not minding anything we may have said before, or I may have said, the fact of the matter is that the very count 7 laid under Criminal Code Act Cap C45, my lord, is not Nigerian law. It doesn't exist. It just doesn't exist. Why should I be in detention over charges that don't exist, my lord? It doesn't.
You are sitting the 2 minutes.
Okay. Just, yes, please.
So, as we can see, he was given that 2 minutes to make that position, to make his position, and the judge had to call him and say, well, you are exceeding your 2 minutes. And in this case, he has to do the needful. So in this case, let's go back to the courtroom, and keep listening through Channels TV what is happening in the court.
Presentation of this case, and same was closed on the 19th day of June 2025. It is worthy to observe that during the time when the prosecution was calling its witnesses, several adjournments were at the instance of the defendant. For instance, on the 29th day of April 2025, the defendant sought for an adjournment for cross-examination of PW1. Also, on the 2nd day of May 2025, the defendant's counsel also sought for adjournment for continued cross-examination of PW1. Likewise, on the 18th day of May 2025, the defendant counsel applied for adjournment. In addition, on the 14th day of May 2025, defendant applied for an adjournment. Also, on the 21st day of May 2025, defendant applied for an adjournment as part of the options opened, or as part of options after the close of the case for the prosecution. The defense opted for the option of filing no case submission, which this court duly had after adoption of written addresses. Ruling was delivered on the 26th day of September 2025, wherein the no case submission was overruled. The issue of extraordinary rendition, validity of the charge, all were incorporated in the no case submission. After going through the no case submission, the court overruled same, and the defendant was called upon to enter his defense. In the ruling delivered on the 26th day of September 2025, the court emphasized and laid importance to the issue of fair hearing, as contained in Section 36 of the Constitution, that the defendant shall be given opportunity to defend the charge he is facing. Upon this, the defendant was called upon to do so. The court in that ruling also pointed out the need for evidence to be given on oath, to give evidence on oath to challenge the evidence of the prosecution. In that no case submission ruling, the court mentioned the importance of defendant to give evidence on oath because this is a criminal matter. It is not civil, where the standard of proof is on balance of probability. It is a criminal matter which the standard required under Section 135 of the Evidence Act 2011 is beyond reasonable doubt. It's worthy to note. that extraordinary rendition is a quasi-criminal issue in a criminal case, and evidence on oath must be given, and the opposing side must be given opportunity to cross-examine on that quasi-criminal issue in accordance with Section 135 of the Evidence Act 2011. Also see the case of Edevie versus Orovobe citation supply, where the Supreme Court held that where any allegation of crime or quasi-criminal are made in any matter, even in a civil matter, affidavit evidence will be insufficient and only oral evidence will be entertained due to the standard of proof being standard required in criminal matter, which is beyond reasonable doubt. These defendants had the duty to prove the allegation of extraordinary rendition in this criminal matter beyond reasonable doubt. The defendant has not called anybody to testify on oath in respect of extraordinary rendition, which would enable the other side to cross-examine such witness. The failure of the defendant to give evidence on oath on extraordinary rendition has made the allegation bare. It is simple an assertion without proof. The court was constrained to deliver the no case submission ruling earlier, as during the vacation of this court, the defendant has filed an application that he be moved to a private ward in the National Hospital, Abuja, as the facility of the Department of State Security Service were not adequate to take care of his health. The court had quickly rushed back due to the importance of health of the defendant. The court ordered the president of Nigerian Medical Association to constitute a panel of experts to carry out tests on the defendant to ascertain his health status and whether he is fit to stand trial. The need to ascertain his fitness to stand trial was based on the antecedents of causing delay in this trial. The court was suspicious whether the issue of medical reports raised at that stage was empty of the ruling and laying foundation for usual delay, which has been the trend since 2015. Based on this, the court added that the medical panel ascertained whether the defendant is fit to stand trial. It is actually a mystery to this court that a defendant who is standing trial would delay his own trial, while shouting that he is being denied his right to fair hearing. Usually, it is the prosecution that delays the trial as his life is not on the line. But in this case, the reverse was the case. The order of the court to ascertain his fitness was strategic to nip in the bud any attempt by him to further delay his trial. On the 16th day of October 2025, the court ruled on the medical report issued by the panel set up by the president of the Nigerian Medical Association and determined that the defendant is indeed fit to stand his trial after no opposition from the defendant and the prosecution as regards the report. The court had carefully observed the defendant during the entire trial and the spirited nature of the defendant. His unruly attitude and his agility in defending himself shows without that he is indeed fit to stand trial. Thus, corroborating the conclusion reached in the report by the panel set up by the president of Medical Association, even without the medical reports, the fitness of the defendant is clear to any reasonable person who observed him in court. His claim of being low on potassium in hospital are not such that render him incapacitated from understanding the proceeding in this trial. He is healthy, fit, and abreast of all the happening in the trial, and demonstrated full understanding and fitness after taking over his defense himself from his counsel. I therefore hold, without doubt, that the defendant is fit to stand this trial. The court then proceeded to give the defendant 6 consecutive days to open and close his defense. Counsel to the defendant, Chief Kanu Agabi, had prayed the court to allow the private consultation between the defendant and his counsel in preparation for his defense. Despite the fact that there was no evidence before the court of the DSS dropping on the conversation of the defendant and his counsel, the court graciously asked the defendant and his counsel to use the courtroom for their pre-trial meeting, since they felt more comfortable in the court. The development meant that the court had to clear the courtroom, and it meant that the court could not conduct hearing in the morning of 22nd day of October 2025, just to accommodate the defendant and his counsel. The court then adjourned the hearing for 23rd, 24, 27, 28, and 29 and 30th October 2025 for the defendant to open and close his defense. On the 23rd of October 2025, the learned Sikh representing the defendants, including Kanu Agabi SN, Onyechipe Azu SN, Bondokoro SN, announced to the court that they wished to withdraw their appearances, as the defendant has indicated that he wanted to defend himself. The defendant confirmed the development and informed the court that he wished to represent himself at the trial. Upon exercising his right to defend himself, the defendant came on the next date, and his excuse was that he was not given his case file by his departing counsel. This was no doubt another cause of a delay on his part. The following day, the defendant appeared for himself and began challenging the decision of the court, arguing that there was no charge against him and that the medical report certified him fit was allegedly doctor. The court patiently explained to him that some of these issues he is raising have been treated in no case submission, and some of other issues could be raised during the final address. The court then advised him to engage counsel who are experts in criminal litigation due to the seriousness of the charge against him. The court also offered to secure the service of counsel from the legal aids or a private legal practitioner willing to take the matter pro bono, which were all rejected by the defendants. The court continued to appeal to him and even went as far as begging him, in the name of God, to please engage counsel and open his defense, all of which fell on the deaf ear. At a point, the defendant informed the court that he wanted to call about 28 persons as witnesses, some of whom he claimed are foreigners as witnesses in his case. He applied for witness summons. The court graciously immediately approved the witness summons. However, the defendant abandoned these said witnesses and began claiming that he had gone through the case file and he found that there was no law providing for the offenses he is being charged with, that he could not defend a charge not found on the law. By this time, the defendant has still not opened his defense. Neither was there any seriousness on his part to put in his defense. The court, in discharging his duty to do justice, calmly and patiently advised the defendant to be cautious of the path he tended to take, as it was tantamount to resting his case on the part of the prosecution, which means that he admits the fact, evidence against him, but believes that it is insufficient to secure conviction against him. This court has been extremely patient and lenient with the defendant. He is only entitled to be given opportunity to defend himself as part of his right to fair hearing. Failure to use that opportunity granted by this court will be entirely his fault. He cannot complain thereafter of fair hearing. The right of a defendant to defend himself, herself, is a fundamental right, provided under Section 36 of the Constitution of the Federal Republic of Nigeria as amended. Such rights cannot be taken from a defendant except where a defendant expressly or by conduct waives same. See Shegun Ogunsoya and the state citation supplied. The defendant refused to open his defense, despite the court informing him that it was minded to extend the day.
At this point, the prosecutor is really now what has happened and the proceedings. But there is a video that I think is of interest to all of us. According to the cables that published this video moments ago, before this time, after Nnamdi Kanu had that back and forth and argued that the court lacked jurisdiction in trying him, um, after that he argued that the court lacked jurisdiction in trying him, he lost his cool, and the following here happened in court.
And you're a judge. You claim you're a judge. You don't know law. You don't know law. Nonsense. Where is the family address? Where is it? Which law gave you the right to go to the family address? Which law gave you that right? Nonsense. And you want to try this? And you want to leave the place and try with me? And you want to try to do this stuff? You don't know. What is this one doing here? What are you 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 doing here? This is the idiot that attacked me. This is the fool that attacked me. That's the idiot that attacked me. That's the fool. Don't touch me. Don't push me. I'm going. Don't touch me. I'm warning you. Don't touch me. I'm warning you. Don't touch me. Don't touch me. Don't touch me. I said don't touch me. Don't. Mad people. You don't know law. Show me where it says you can work my right. Show me the law. Show me the law. I want to show me the law. You don't know law. They are reporting you. You are writing rubbish. Show me the law. One address. I see the thing. He said, I think they are not for them. God will punish you. Now and forever. Any judgment, let it be on record. Any judgment in this court is rubbish. Ask him where is the law. Ask Omotosho, where is the law? Where is the law?
So that's very hard to watch because at this point, one would have thought that this level of engagement probably would have ceased. I would have loved to have seen Ikpeazu SAN, one of the best. I don't know. I don't need to be regurgitating this. I would love to see Agabi, Ikpeazu, and co arguing this, arguing this and making this, making points on the point of law. Now, like I said before, the judge himself was gracious enough that, if I don't know where I watched it, someone was saying that the judge could be accused of having interests, the way he was begging when he had the announcement that the legal team has been disbanded. And the person made the argument, oh, why would the judge be begging someone to get a legal team, and give time for that to happen? And you can also see the way the legal team is now, quote unquote, being referred to as consultants. There are times we may have some ideas as to what we are doing, but at times professionals who have been trained in this matter are left to do their job. And if you ask me, I believe more than any time ever, this would have been the time, because the last team that he had, I had so much confidence based on their track record and their reputation. Most of these people in the court are their juniors, so they know the law in and out. But it is what it is. So let's go back to the court and continue listening to what's happening there.
I do. Register asking, are you guilty or not guilty? Defendant responded, not guilty. Count 5. Register read and asked him, do you understand count 5 that I've read to you? Defendant responded, I do. Registrar, are you guilty or not? Defendant responded, not guilty. Count 8, now count 6. Registrar read and defendant, do you understand count 6 I read to you? Defendant said, I do. Registrar, are you guilty or not? The defendant responded, not guilty. Count 15, original 15, now count 7. Registrar read and said, defendant, do you understand count 7 I read to you? Defendant responded, I do. Registrar asked him, are you guilty or not? Defendant responded, not guilty. The defendant clearly understands English language, being an educated man. On that day, he had his counsel, including senior advocates such as Kanu Agabi, SN, representing him on that day. The court complied with the procedure of taking the plea of the defendant in accordance with section 271, 2, and 3 of the Administration of Criminal Justice Act 2015, which provide thus: 1. The defendant to be tried on a charge or an information shall be A. brought before the court unfettered unless the court sees cause otherwise to order, and the charge and information shall be read over and explained to him to the satisfaction of the court by the registrar or other officer of the court. B. Called upon to plead instantly unless where the person is entitled to service of the information he objects to the non-service, and where the court finds that he has not been duly served. 3. The court shall record the fact that he is satisfied that the defendant understands the charge or information read over to him and explained to him in the language he understands, and shall record the plea of defendant to the charge or information as nearly as possible in words used by him. Looking at the above statutory provisions of Administration of Criminal Justice Act, the procedure adopted by this court, the defendant cannot turn round to claim he was misled to take plea after the prosecution has closed his case. It is nothing but the usual habitual flaw of the defendant to cause delay and make the matter to start de novo. This court will not allow matter to be on its court list ad infinitum. On the issue of denial of adequate facilities, the defendant claimed that he was not allowed to consult with his legal representation in confidence at DSS, as the DSS officers were dropping on their conversations. The defendant is facing criminal trial and is entitled to the right to adequate time and facility in preparation for his defense. He enjoys the constitutional right to fair hearing, and in consequence to this right, has the right to adequate facilities as his defense. Section 36 6B of the Constitution of the Federal Republic of Nigeria 1999, as amended, provide every person, I quote, every person charged with criminal offense shall be entitled to be given adequate time and facility for the preparation of his defense. See the position of the Supreme Court in respect of this provision as initiated in Igwe and the states. Citation supplied. As part of the package of rights available to a person facing criminal charge, he is entitled to all the facilities and enough to time for purpose of preparing his defense. This ties in with the right to presumption of innocence under Section 36(5) of the Constitution of the Federal Republic of Nigeria 1999 as amended, which stipulates that until a person is declared guilty by a court of law, he is presumed to be innocent. The provision was the subject of interpretation by the Supreme Court, particularly by my noble Lord Akat JSC in Okoye and COP. Citation supplied, where my Lord said, and I quote, the moment an accused person is facing a charge, his personal liberty is at stake, and before that liberty is taken away, he must be afforded every opportunity to defend himself once he becomes aware that he has a charge hanging upon his neck for an infraction of the law and makes a request either orally or in writing for any facilities to prepare his defense. The court must accede to his request and the prosecution has to comply. The facility that must be afforded the accused person are the resources, anything which will aid the accused person in preparation of his defense to the crime for which he is charged. This, no doubt, includes the statements of the witnesses interviewed by the police in the course of their investigation, which might have absolved the accused of any blame or which may assist the accused to support such favorable witness that the prosecution counsel may not want to put forward for to testify, unquote. See case of Nweke and the state citation supply. The defendant did not provide any credible evidence as to this allegation of airdropping. The court, however, in order to do justice to him and suspecting that he was looking for another way to delay this trial, allowed him to consult with his lawyer on the 22nd day of October 2025 in the courtroom. Thus, the court had to vacate the courtroom for him, his lawyer to use. Despite this magnanimity by the court, the defendant did not make use of this opportunity. On the following date, the counsel withdrew his appearance. The defendant decided to defend himself, making the opportunity given to him to use the courtroom to be useless and of no purpose. Despite the fact that he is not a legal practitioner, he began using some of his counsel, who he had earlier disengaged, to act as legal consultants to him. The court even kindly ordered the DSS to allow these consultants have free access to him. This is in compliance with Section 36 of the Constitution of the Federal Republic of Nigeria, which provides for access to legal practitioners. Most of these legal consultants were always present in court. There is nothing to show that he was denying adequate facilities to prepare for his defense. He had enough time to prepare. He had been represented by senior advocates such as Kanu Agabi SAN, Onyeshi Impeazu SAN, Emeka Ipamas SAN, Paul Urokoro SAN, Haudunoge SAN, among others, before they were suddenly disengaged. And the defendant decided to represent himself, which this court suspected was also to cause another delay in the hearing of this matter. His allegation holds no basis in this case. Consequently, this issue is resolved against the defendant. On the issue of extraordinary renditions, there are instances where a person commits offense against a country while residing in another country or flee the country soon after committing the same crime. In such instances, the country against which the offense is committed will request the country in which the suspect is residing to release him to it. The process is known in law as extradition. Extradition therefore refers to a crime to the state against which the crime was committed, known as requesting nation. The Supreme Court in AG of Federation versus Enubuwa citation supply subsequently explained the concept of extradition as follows. Extradition is a cooperative legal process of one state called the surrendering state or authority which renders an individual to another state called the requesting state for prosecution or for punishment for crime committed within the requesting country jurisdiction. Extradition process is usually spelled out in bilateral or multilateral extradition treaties or agreements. Extradition becomes necessary when a criminal fugitive flees from one country to another to avoid facing trial or punishment. Persons who may be extradited include those who have tried and convicted but escaped custody by fleeing the country and thus convicted in absentia. A trial in which the accused person is not physically present. Extradition is distinguished from other modes of forceful removing undesirable persons from a country, such as exile, expulsion, deportation, extradition procedure, are usually determined by the terms of the treaties between individual countries or by multilateral agreements between group of countries, such as the Commonwealth countries, or its law. Its treaties specify obligations to the requesting nation and decide whether or not to extradite the persons named in the warrant. Treaties signed in recent decades tend to take a dual criminalities approach, classifying and extraditable offenses that are punishable in both jurisdictions. Other extradition treaties, by contrast, tend to list covered offenses, unquote.
I think this man should be, should be reading.
Usually,
quickly. We can't sleep
the
here.
requesting and surrendering nation have
please.
a treaty or agreement which allows for such transfer. Nigeria, for instance, is signatory to regional agreements like the ECOWAS Convention on Extradition and other multilateral schemes, such as the London Scheme for Extradition, which within the Commonwealth. The London Scheme for Extradition within the Commonwealth enables Nigeria to request and surrender fugitives to member nations of the Commonwealth. On the other hand, extraordinary rendition is an extrajudicial measure to forcefully bring suspect or defendant to the country against which an offense is committed. These extraordinary measures may be made
Okay, let's see what's happening. I think Channels TV, see, probably we can move on to
include adoption. This versus Nnamdi Kanu in SC/C CR/13C1 2022, where my noble lord Agim JSC had, and I quote, generally abduction or kidnapped or any form of illegal removal citation supply. His defendant did not provide any credible evidence as to this allegation of airdropping. The court, however, in order to do justice to him and suspecting that he was looking for another way to delay this trial, allowed him to consult with his lawyer on the 22nd day of October 2025 in the courtroom. Thus, the court had to vacate the courtroom for him, his lawyer to use. Despite this magnanimity by the court, the callings 342 US 519 1952. It was a case where the defendant was tried and convicted in the state of Michigan after being adopted by Michigan authority from Chicago, Illinois, applying its decision in care. The Supreme Court upheld the conviction of the conviction over challenges based on due process and federal kidnapping law. The essence of Kerr Freebie doctrine is that even though the act of rendition is illegal, a trial court may assert jurisdiction over the person regardless of the legality of the adoption under international law. In recent times, the Supreme Court relied on Kerr Freebie doctrines in United States versus Alvarez Merchant in 504 U.S. 65 1992. Alvarez Merchant, a Mexican citizen, was adopted and brought to the United States as the direction of the Drug Enforcement Administration. The Supreme Court of the United States held that despite his forceful adoption from Mexico by United States official, it did not affect the validity of his trial in the United States. As said earlier, the issue of extraordinary rendition is quasi-criminal issue, which must be proved beyond reasonable doubt in accordance with Section 135 of the Evidence Act 2011. The law in Nigeria is right that even a civil matter, once a criminal element is introduced, it must be proved beyond reasonable doubt. For instance, where an allegation of forgery is introduced in a civil proceeding, the standard of proof is proved beyond reasonable doubt. See the case of Minister of FCT versus Finance Consultancies Services Limited and another, citations to supply, where the Court of Appeal held, and I quote, every forgery involves an alteration of documents, but not every alteration of documents amount to forgery. Forgery involves alteration with a fraudulent intent. The fact and incident of forgery must be specifically pleaded and proved, even in civil matters, as in this case, beyond reasonable doubt. The appellant in this appeal has made allegation of forgery, but failed to prove same. In a case of forgery, both the original document and the fake must be produced in court for examination. The appellant failed to produce any document in proof of these forged documents. Allegation of such forgery in any civil matters is criminal in nature. Therefore, proof is beyond reasonable doubts. See also the case of Muni versus Federal Republic of Nigeria, among other authorities. The evidence in proving an unlawful extraordinary rendition must be oral evidence obtained which allows the adverse party to cross-examine the defendant on his oral evidence. The defendant only swore to an affidavit. So the fact that the affidavit evidence is best used in civil proceedings, where the standard of proof is on balance of probability. The affidavit filed by the defendant is grossly insufficient to establish if indeed he was extraordinarily rendited or he was illegally brought to Nigeria. The gaps in evidence will therefore mean that no evidence was led regarding the extraordinary rendition. Assuming, without conceding, that there was evidence regarding the extraordinary rendition, the court will consider the effect of the extraordinary rendition on the validity of the trial of the defendant. The defendant, in his written address, has argued strenuously that the way he was brought back from Kenya was illegal and thus vitiates his trial before this court. He relied heavily on the decision of the Court of Appeal in Federal Republic of Nigeria versus Kanu, in appeal number CA/ABJ/CR/625/2022, delivered on the 13th day of October 2022 on the issue. The court held, and I quote, the consequence of this session, I hold that the respondent is prohibited from being detained, tried, or otherwise dealt with in Nigeria for or in respect of any offense allegedly committed by him before his extraordinary rendition to Nigeria. The lower court thus has no jurisdiction. I further hold to try the appellant on counts 1, 2, 3, 4, 5, 8, and 15, which were retained by it, being charges allegedly committed by the appellant prior to his extraordinary rendition. In addition, by the forceful adoption and extraordinary rendition of the appellant from Kenya to the country on the 27th day of June 2021, in violation of international and state law, the lower court or indeed any court in the country is divested of jurisdiction to entertain charges against the appellant, and I so hold, unquote. When this issue came up before the Supreme Court, the Apex Court, in Federal Republic of Nigeria versus Kanu, in SC/CR/1361/2022, delivered on the 15th day of December 2023, the Apex Court held per ML Gaba JSA, and I quote, my noble Lord ML Gaba JSC, I agree with the learned senior counsel for the appellant that the procedure used in bringing or producing the respondent before the trial court for the trial of the offences in the counts of the charge in questions in respect of which he was validly arraigned did not affect or even go to the statutory jurisdiction of that court to proceed with that trial. The procedure, mode, manner by which the respondent was produced before the court is in before the trial court is in law extraneous to the statutory jurisdiction vested or conferred on the trial court to try or adjudicate over the offences in question, particularly after the valid arraignment of the respondent and his plea thereto. The procedure used in producing the respondent to face his trial after the arraignment and plea to the offences and after jumping the bail granted to him by the trial court cannot reasonably be said to deprive or rob that court of the requisite statutory jurisdiction to adjudicate over or try the offences in questions. In the above premises, the lower court, which is with the respect due to it, took its eye off the balls when it filed off the statutory jurisdiction vested on conferred on the trial court to subject it to procedural law dealing with the procedure for the arrest, extradition, or rendition of runaway fugitive offender to and from the foreign country. The provision of Extradition Act Cap E25, Laws Federation of Nigeria 2004, articles and parts of the UDHR 1964 and pronouncement of foreign courts on them referred to and solely relied on by the lower courts to hold that the procedure used or employed to produce the respondent before the trial courts to continue his trial had robbed that did not create, defined or punish the said offences. Neither did any of them conferred or vest the statutory judicial power and authority or jurisdiction to try adjudicate over the offences in respondent was charged with and validly arraigned for. Rather, they all merely provide or prescribe for the general procedure to be adopted in respect of their respective subject matter that do not include and have nothing to do with creating, defining, or punishing offences, and vesting or confining judicial power and authority or jurisdiction on courts to advocate over or try such offences. Once again, these laws and rules, conventions, etc., do not take away, deprive, or rob the jurisdiction of the trial court to adjudicate over or try the offences the respondent was arraigned for on the basis of procedure used or employed to bring or produce him before the trial court for continuation of his trial. I must emphasize that even this court, as the apex court in Nigeria, cannot, by pronouncement, take away, deprive, or even fetter the jurisdiction or conferred or vested on the court of record by the constitution or a statute, let alone pronouncement by foreign courts on such foreign international convention, treaties, and agreements, or even if domesticated. In this result, the issue is resolved in favor of the appellant to the effect that the trial court is statutorily vested or conferred with the requisite jurisdiction to adjudicate over and try the offences in the retained counts of the charge the respondent was validly arraigned for, and that the procedure used and employed to bring or produce him for the continuation of his trial did not rob or deprive that court of jurisdiction. It was an error in law for the lower court to resort to and hold that the procedure law procedural law, or entirely different subject matter of arrest, extradition, or rendition of runaway fugitive offenders, accused person from foreign country, deprived or robbed the trial court of the statutory jurisdiction. My Lord argued in the same case also adds, and I quote, the established case law through the cases is that even though a strict alliance to statutory prescriptions concerning pre-trial criminal processes, the processes for bringing the accused to court for trial is a sine qua non for fair trial. Violation of the fundamental rights of an accused person or other unlawful action by the prosecution at the pre-trial stage give the accused person the right to action for remedy for violation of his fundamental rights and other civil remedy, and has no effect on the validity of the whole criminal proceedings against him and the jurisdiction of the court to entertain the proceedings and try him, provided the facts alleged against him disclose an offense created by written law and a reasonable basis for suspecting he committed the offense. So the established case law in Nigeria is that violation of fundamental rights of an accused person and any illegality in pre-trial or extraordinary process in relation to an accused person should not affect jurisdiction of the court to try ensuring criminal cases and the validity of such case. That is the basis for the admission of relevant evidence obtained from illegal searches and seizures or searches that violates the accused person's fundamental right to privacy. In Nigeria, there is hardly any case where the jurisdiction of a court to try a case is declared to be ousted by or validity of the case declared vitiated by the unlawful arrest and detention of an accused person at the pre-trial stage of that case, or by any unlawful extrajudicial action of the prosecution after arraignment during the pendency of the proceedings in court. The Court of Appeal has introduced a departure from the established case law on the points in Nigeria. What is not clear is if the departure is limited to cross-border cases or include cases within Nigeria. But the erudite restatement of the House of Laws in Howe versus Osprey relied on by Court of Appeal are couched in terms that suggest that they apply to all cases. This profound judicial restatement appears to give paramount consideration to preventing executive lawlessness, protection of the fundamental rights of the accused, preservation of the rules of laws, promotion of rights for for territorial sovereignty of states, enforcement of international law, adhering to due process of criminal law to ensure that prosecution does not benefit from abuse of its power and abuse of court process. But the reality in Nigeria's peculiar situation is that no allegation of commission of a crime will be tried if the court declines jurisdiction to try a criminal case or invalidate it because of the violation of fundamental rights of the.
So for those of you who are asking who is reading and what is the reading, what is being read is the judgment. The voice you're hearing is the voice of Justice Omotosho. So he's taking everything point by point. Now, for those of you who just joined us, I would also use the opportunity to make some explanation also. There was an altercation between the court, between the judge and Nnamdi Kanu at some point. Nnamdi Kanu was given the chance to make his presentation, which he did, and he eventually wanted, okay, let me play us his presentation here for clarity's sake. Just listen to this.
An order, this motion, my lord, was filed on the 12th day of November, praying this honorable court for the following reliefs. An order referring the substantial constitutional questions raised in this trial to the Court of Appeal pursuant to Section 2952 of the Constitution of the Federal Republic of Nigeria, and an order staying further proceedings pending the determination of those referred questions. The supporting affidavit was deposed to by my younger brother, Prince Nnamdi Kanu, together with all annexures. My Lord, my written address filed in support of the motion, wherein I adopted and argued the 3 jurisdictional issues submitted to your Lordship for your determination. There was also a further and better affidavit and my reply on points of law filed in answer to the respondent's counter affidavit and written address. My Lord, I respectfully urge your Lordship to deem all these processes as argued and to grant the reliefs exactly as set out on the motion paper. And in a brief overview of what is contained in my motion, my Lord, my contention is very simple. That ab initio, this court lacks jurisdiction to try me, that this very court is a material defiance of an appellate court judgment, the Supreme Court, with specific regards to count 7, which does not exist in the laws of this very country, and which the Supreme Court mandated this very court to amend. That hasn't happened. The presence of count 7 on this charge sheet, my Lord, nullifies this entire proceedings completely and totally, because count 7, my Lord, does not exist in the laws of this very country. When I reply on points of law, I will make specific references to the ratio that came down from the Supreme Court, where my Lord Lawal Garba explicitly stated that count 7 should be changed. That hasn't been done, my Lord, and this court is in contempt of the Supreme Court binding order. My Lord.
Okay, so you've seen at this point, Nnamdi Kanu made his submission. He went ahead to also say the following.
Reply.
Sorry, not him. He made his submission. Then the defendant, the prosecutor in this case, argued against what he presented, that the court lacked jurisdiction to try him. This was what the prosecutor said.
To the first motion on the 14th of November 2025. We also filed a reply, a counter affidavit and a reply in respect of the first motion. For the second motion, we also filed a reply, all on the 14th of November 2025. For the third one, for the further application for bail, we did not file any counter affidavit. So for the first one, sir, I respectfully adopt the counter affidavit of the prosecution and the written address. And we urge your Lordship to dismiss the application because it's a regurgitation or repetition of the well-worn argument that the counts which the defendant pleaded to were unknown to law. It is for your Lordship to determine that in other ones. Well, the one asking for stay of proceedings, my Lord, our argument is to the fact that the statute does not permit your Lordship to grant any stay of proceedings or injunction. So we urge your Lordship to dismiss it. And for the second, we also filed a written address dated 14/11. We adopt it with all respect, and we urge your Lordship to dismiss the application as lacking in merit. For the last application, asking for the defendant to be admitted to bail on the same ground that, the counts to which he pleaded not guilty were unknown to law. Again, is a repetition of the old argument. It is for Lordship to determine whether the laws were valid, whether his plea was valid, and whether he is answerable to the law when he committed the terrorism acts. The terrorism acts he committed was...
Please,
So we urge your Lordship to dismiss the application. On the other ground is also to the fact that the applicant has another pending motion filed in March, in April 2025, asking for the same relief, bail. So the latter application with respect, is an abuse. In any event, none of them merits. We urge your Lordship to dismiss it.
Please, let's save this.
Okay, so he's urging the judge to dismiss Kanu's submission. Now, because we are following this sequence by sequence, right? Kanu here made a case for his final written address, which I do not know why. I thought when he addressed the court was his final address, but for whatever reason, whether that is only meant for lawyers to, I don't know. But to be honest with you, some of the things that I'm looking at here, what I'm trying to do is to be fair and bottle emotions, where, basically to look at this thing objectively. And in looking at this, okay, Rookie said it's a comprehensive report. Okay. But in looking at this, I do not think if this was a senior lawyer, SAN, I don't think some of these dramas that we witness today would have been the case. It would have been really senior lawyers, who know criminal justice system by the tip of their fingers, will be arguing with one another. I mean, again, some of these things probably wouldn't have degenerated in this sense, but hey, this is where we are today. We can't change this, and Nnamdi Kanu had the following point to make.
Address is a constitutionally mandated right, which I must be granted. It is in the constitution of this very country that final written addresses, my Lord, must be granted. I have not waived it, my Lord, and I insist that I address this court on all these issues. My Lord, do not permit.
Defendant?
My Lord.
Consultant, can you tell your...
My Lord, I will not, please, let me finish.
Please.
It's my case.
I've gone...
It is my case, my Lord, let me finish. My Lord, this very court, another idea that FAN was here, my Lord, another idea that FAN said, at the right time we will contradict and develop a piece of evidence. A piece of evidence given the court. I need to write my family to address my Lord
on a count charge which reads thus.
My Lord, my Lord, I'm saying it clearly.
Defendant.
Now, the case here is that Nnamdi Kanu is saying that he needs to write his final written address. When the date was set for final judgment, or for the judgment, it is expected that today you would have come with your final written address. So in this case, what I do not understand is if he's asking for this judgment to be moved in order to give him time to write his final written address, which according to the court should have been ready today. Now, do you think if that was, senior advocates and their team, that they should not have been able to get this into I don't know, but honestly, I struggle to really understand the strategy behind the sack of all the legal counsel, and um, you know, maybe it's a good strategy that may work in his favor. I honestly pray it does. That it does work in his favor. That the sack of those individuals will not be something that will work against him. So let's listen to him finally.
Defendant, can you listen to the court? Please. Can you listen to the court?
I need to find my family within the Constitution.
I appeal to you.
Yeah, his microphone at some point is cracking because either the battery is dying or the range was moved. I don't know, whatever is the case. But he's now arguing with the judge, Justice Omotosho, on that back and forth. And the judge is appealing to him to listen to him on what he's saying.
To comport yourself.
Now the judge is saying, please, I beg you, can you comport yourself? And I think at this point, he's already very angry and worked up.
It's temple of justice.
You are bad. This is not law. You are bad. It's not law.
Please, I beg you to comport yourself.
My lord, this is not law. Show me where it says you can wait my right.
Beg you to
show me
yourself.
Show me where it says you can wait my right to family within a place.
You
show me
in the
my lord, you are conducting the case for them. You are holding the case for them. Let them show me the Constitution. Show me where it says you can wait my right to within a place.
You have the right to appeal after my.
No, this is your perversion of the court of justice. This is not law.
Can you excuse me?
My lord, I cannot excuse.
Let him take out.
It's not possible. It is not possible. My lord,
Take him.
you must show me where the Constitution says you have the right to work with the place. You must show me.
Excuse him.
Show me. Show me where it says so. Show me. Show me where it says so.
Excuse him at.
Is that how you brought the camera? Is that how you brought them today?
Please.
You didn't bring it before. You brought it today?
Please.
Show me where it says you can find me on the repeat law. Show me.
Please get the microphone from him, please.
I said, show me. Show me.
Excuse me. Get the microphone from him.
So at this point, the judge has ordered that the microphone be taken away from him, as he was not then listening to him. I know many of us are saying he had the right to shout at the judge. He has the right to be angry because it's about his life. Again, you're right. It's an emotional time, and people react to issues differently, right? So at this point, the microphone, just watch.
Leave it. I said, leave it. It's a court of law. I'm under trial. I'm under trial. I have to speak. I'm under trial and I have to speak. Listen to me, please. I'm under trial. I'm under trial.
Please use the microphone.
I'm under trial. And I must address the court. Please, wait. No, listen to me. Please.
The judge must listen to me. No, wait. I'm asking a very simple question. No, wait. Please. This is Supreme Court. Wait, hold on. This is Supreme Court here. Hold on a second. May please, your lordship. I said, hold on. May you please, your lordship. Please. May I?
Now, in the court of law, the judge controls every single pin that drops. So I think at this point, with this altercation, the judge now requested that Nnamdi Kanu be escorted outside the courtroom. And that's when heaven was let loose. At this point, he you better hear them yourself. He now had the following to say to the judge.
Show me! Show me! Which law says you can try me an unwritten law? Show me, you cannot show me. You're a judge. You claim you're a judge. You don't know law. You don't know law. Nonsense. Where is the family address? Where is it? Which law gave you the right to waive my family address? Which law gave you the right? What's this one doing here? What are you 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 doing here? This is the idiot that attacked me. This is the fool that attacked me. That's the idiot that attacked me. That's the fool. I'm telling you, don't talk to me. I'm warning you, don't talk to me. I'm warning you, don't talk to me. Don't talk to me. Don't talk to me. I said, don't talk to me. Smart people. You don't know law. Show me where it says you can wear my right family address. Show me the law. Show me the law. Omotosho, show me the law. You don't know law. They are demoting you. You're writing rubbish. Show me the law. Unaddressed affidavit. You say you waive it. Are you doing their job for them? God will punish you now and forever. Any judgment, let it be on record. Any judgment given in this court is rubbish. Ask him what is the law. Ask Omotosho, what is the law? What is the law?
So at this point, he was escorted outside the court by the DSS. But before he left, he walked and turned back to his prosecutor and rather the prosecution team and said, God will punish you, right? So let's see if they are still reading the final judgment. So let's go back to the court and see, and probably what the judgment will be.
The Terrorism Prevention Amendment 13 was repealed, and such is liable to affect the validity of the defendant's trial. I refer to Section 98 of the Terrorism Prevention Amendment Act 2022, which provides 98. 1. The Terrorism Prevention Act number 10, 2011 is repealed. 2. Any regulation, order, requirements, certificates, notice, direction, restrictions, authorizations, consents, applications, ongoing cases in courts, requests or things made, issued, given or done under the Repeat Act shall, if enforced at the commencement of this act, continue to be enforced and have effect as if made, issued, given, or done under the corresponding provision of this act. 98.3 provides any proceedings, prosecutions, sentence, judgments, charge, or cause of actions pending or existing immediately before the commencement of this act under any of the repealed acts in respect of any rights, interest, obligation, or liability may be continued and commenced as the case may be, and any determination of any court of law, tribunal, or other authorities or person may be enforced to the same extent that such proceedings, prosecutions, sentence, judgments, charge, course of actions, or determination might have been continued, commenced, or enforced as if the act has not been made, unquote. The imports of this provision, particularly Section 98.8 98.3 it serves as a saving provisions, which ensure that the amendment of the Act does not affect the validity of trial begun under the Repeal Act. This saving clause or preservation provision is aimed at ensuring that pending proceedings or order of courts are not washed away as a result of the commencement of the amended Act 2022, but to ensure a smooth transition from the Repeal Act to the amended Act. The sum total of this is that the enactment of the Terrorism Prevention Amendment Act 2022 does not vitiate the trial of the defendant rightly commenced under the Terrorism Prevention Amendment Act 2013. Consequently, this issue is resolved against the defendants. With respect to the substantive issue, I must start the resolution by outlining the effect of the action of the defendant in failing to put in his defense despite several opportunities afforded him by this court. Generally, in criminal trial, the defendant has the three options available to him. Upon the closure of the prosecution case, he has the option of making a no-case submission to argue that the prosecution has not made out a prima facie case against him to warrant him to enter his defense, or that the evidence led by the prosecution so far had been so discredited under cross-examination that it would be unsafe for the court to convict him. Another option open to a defendant is to put in his defense where he will be opportune to state his side of the story as well as present exculpatory evidence in his favor. The third and the final option is to rest his case on that of the prosecution. The defendant in this case chooses to make no case submission, and this court overruled his no case submission on the 26th day of September 2025 and ordered him to put in his defense. It is his constitutional right to do so. He, however, refused to do so. He rather consented to the withdrawal of his learned senior counsel representing him, despite the court employing him to enter his defense on several occasions, even begging him, in the name of God, as a minister in the temple of justice, passionate about justice, as an apostle of Jesus Christ, I begged the defendant passionately and severally, but the defendant was obstinate and refused, and the court had no choice than to foreclose him. The effect of this is that the defendant has chosen to rest his case on that of the prosecution. The defendant this morning confirmed this fact by saying that he has put in his defense. The effect of the defendant resting his case on the prosecution is that it is a gamble, a risky option, which may boomerang if the evidence adduced by the prosecution is believed by these courts. The Supreme Court in Adamu and State, citations supplied, held, and I quote, "The law is generally settled that an accused person who, at the close of prosecution case, decided to rest his case on that of the prosecution as presented against him is only exposing himself to risk and gamble. The reason being that if the case is such that even if all the prosecution witnesses are believed, yet the offense as charged is still not proved, then the accused may get away with the risk of resting his case on that of the prosecution. By that choice, the accused will have decided not to explain any fact in rebuttal of the allegation made against him. See also the position of the Supreme Court in the case of Ajibade and State Citation Supply, where the court held, and I quote, "Appellant elected not to give evidence in his defense, but to rest his case on that of the prosecution. The election is within his rights under the law, but the legal effect of the said election is to leave the court of trial free to accept the uncontroverted evidence of the prosecution in proof of the charge, which the court rightly did, in my view," unquote. See also the case of Hakim Ibiseyin versus Olajide, citation supplied. The defendant in this case deliberately refused and failed to call any witness and present evidence through his witnesses in rebuttal of the case of the prosecution. The implication is that he admits the case of the prosecution, and the court is entitled to rely on the uncontroverted evidence led by the prosecution. With respect to count one of the charge, the defendant is facing a charge of committing an act in furtherance of an act of terrorism against the Federal Republic of Nigeria by making a broadcast received and heard in Nigeria with intent to intimidate the population and threaten that people will die and the whole world will stand still, thereby committing an offense punishable under Section 1(2)(b) of the Terrorism Prevention Amendment Act 2013. The subsection provides a person, body corporate or corporate who knowingly in or outside Nigeria, directly or indirectly, willfully, commit an act preparatory to or in furtherance of an act of terrorism, commits an offense under this act and is liable on the conviction to maximum of death sentence. The ingredients of the offense as drawn from the above are: 1. The defendant must be a person or body corporate. 2. The defendant must have done an act preparatory to or in furtherance of an act of terrorism. 3. The defendant must have done the act preparatory to or in furtherance of terrorism act knowingly or willfully, and same may be directly or indirectly. See the case of Ada versus Federal Republic of Nigeria, citation supplied. Looking at the first ingredient, there is no doubt that the defendant in this case is a person. He is known as Nnamdi Kanu. A man is in 50 who stood trial before this court. Thus, the first ingredient is resolved in favor of the prosecution. For the second ingredient, the prosecution led evidence showing that the action of the defendant in making broadcasts threatening that people will die constitutes a terrorist act. Terrorism or a terrorist act, according to online Oxford Dictionary, is, I quote, the unlawful use of violence, intimidation, especially citizens in the pursuit of political aim, unquote. It is also important to explain what constitutes terrorist acts. Section 1(2) of the Terrorism Prevention Amendment Act 2013 provides us, and I quote, in this section, act of terrorism means an act which is deliberately done with malice, aforethought, and which A, may seriously harm or damage a country or international organizations. B, is intended or can reasonably be regarded as having been intended to: 1, unduly compel a government or international organization to perform or abstain from performing any acts. 2, seriously intimidate the populations. 3, seriously destabilize or destroy the fundamental political, constitutional, economic, social structure of a country or international organizations. 4, otherwise influence such government or international organization by intimidation or coaction. C, involve or causes, as the case may be. 1, an attack upon a person's life which may cause serious bodily harm or death. 2, kidnapping of a person. 3, destructions to governments or public facilities, transport system, and infrastructural facilities, including an information system, a fixed platform located on the continental shelves, a public place, private properties, likely to endanger human lives or result in major economic loss. 4, disposal of an aircraft, ship, or any means of public or goods transport and diversion, or the use of such means of transportation for any of the purposes in paragraph B4 of this subsection. 5, the manufacture, possessions, acquisition, transport, supply, or use of weapons, explosion, or of nuclear, biological, chemical weapons, as well as research into development of biological and chemical weapons without lawful authority. 6, the release of dangerous substances, causing of fires, explosion of flood, the effect of which is to endanger human life. 7, interference with or disruption of supply of water, power, or any other fundamental natural resources, the effect of which is to endanger human life. D, an act or omission in or outside Nigeria which constitutes an offense within the scope of counter-terrorism protocol and convention duly ratified by Nigeria. The Supreme Court, by my noble Lord Kekere Ekun, JSC, now the CJN, heard in Abdul Mumuni versus Federal Republic of Nigeria, and I quote, Section 15.2 of the EFCC Act provides, any person who commits or attempts to commit a terrorist act or participates in it facilitates the commission of a terrorist act, commits an offense under this act, is liable on conviction to imprisonment for life. Section 46 of the Act provides terrorism means any act which is a violation of the criminal code or the penal code and which may endanger the life, physical integrity, freedom of, or cause.
I believe that what we are hearing now, and the justice is taking time to, on the charge of terrorism, is mentioned it multiple times that it carries life. So I hope this is not a prelude to say that he will be found guilty on terrorism charge, because if he does, he is preparing the ground to make pronouncements, in my understanding, that is going to carry a life sentence. But again, this is the reason why I said there will be on this platform by 6 o'clock Nigerian time, we will have legal experts here to take these charges one by one and look at what next. So let's go back to the studio.
Or to create a public emergency or create general insurrections in a state. Any promotion, sponsorship of, contribution to, command, aim, incitement, encouragement, attempt, threats, conspiracy, organization or procurement of any person with the intent to commit any act referred to in paragraph A, 1, 2, and 3, unquote. It was further added, and I quote, the crucial aspect of offense of terrorism is the creation of intense fear and anxiety, both physical and psychological, in the mind of members of the public, which has the effect of coercing, forcing, intimidating them to do or abstain from doing any act or to adopt or abandon a particular view, policy, or position to act according to certain principles, unquote. See also the case of Berende versus Federal Republic of Nigeria, citation supplied. In my research, I came across a handbook from the United States Institute of Peace titled Teaching Guide on International Terrorism. Definition, causes, and responses, where several definitions of terrorism were given as follows. I quote, the calculated use of violence, the threat of violence to inculcate fears, intended to coerce or to intimidate governments or society in pursuit of goals that are generally political, religious, or ideological. Terrorism constitutes the illegitimate use of force to achieve a political objective when innocent people are targeted. Terrorism is defined here as the current use or threatened use of political motivated and clandestine organized violence by a group which aim is to influence a psychological target in order to make it behave in a way which the group desires. See Judgement drag. The unlawful use of force or violence against persons or properties to intimidate or coerce governments, the civilian populations, or any segment thereof in furtherance of political or social objective is derived from Federal Bureau of Investigations. What therefore, unquote, what therefore constitutes a terrorist act from all the definition above is an act of violence. Threat of violence intended to cause fear, puts the recipients of such violence or threat in a state of fear. Applying the above definition to the facts of this case, the defendant in several of
for those
these
asking,
workers
the law
made
does not allow the
several
face of the judge to
threatening
be
harms to
shown
the federal government of Nigeria,
whenever
the general
cameras
Nigerian
cameras
populace,
are allowed
including its own people who claim to fight for, who he claimed
to fight.
he fight for. In an interview with Sahara reporter, in an interview with Sahara TV, contained in Exhibit PWW, the defendant was interviewed by one Rodolphe Okonkwo. He was introduced as the founder and director of Radio Biafra. When the defendant appeared on the screen, his nameplate was Nnamdi Kanu, director Radio Biafra. While speaking on the national conference in Nigeria, which was organized at that time, the defendant mentioned the name of some of the representatives from the Southeast as the conference, and he said, if you go there and negotiate any other thing apart from Biafra, you better not come back because our people will be waiting for you. That very person, unquote. When he was asked about the consequence for this representative, including one Ike Nwanchuku, the defendant was unequivocal when he said, things have changed, and that because the only language that people in the zoo understand is language of violence and force. After all, that very contraction was put together by Frederick Lugard by force. That is what many people don't understand. Lugard killed many people to put Nigeria together, and the killing of people to disintegrate the zoo shouldn't come to anybody as a surprise. Our promise is very simple. If they fail to give us Biafra, Somalia will look like a paradise compared to what will happen to the zoo. It is a promise. It is a pledge. Also a threat to them. they must understand it, that we have had enough of this nonsense, unquote. It is not noteworthy that defendants in the said interview kept referring to the southeastern part of Nigeria as Biafra. The defendants made some comments, such as the governor of the southeastern states being the stooge of Hausa Fulani godfathers. He even stated that Rochas Okorocha, former governor of Imo, had institutionalized the entire state to satisfy his Hausa Fulani godfather. He said nobody had asked Governor Peter Obi about Izu River and the person dumped in the said river. Further, during the interview, the defendants, while answering a question about whether he will embrace a peace separation or choose a violent path, stated at about 7 minutes 30 second mark of Sahara TV interview in Exhibit PWW, which is a flash drive containing all its broadcasts, said, and I quote, "If they do not give us Biafra, there will be nothing living in that very zoo called Nigeria. Nothing will survive there, I can assure you," unquote. He also made reference to the Nigeria Civil War when he said, in 1967 to 1970, it's not 2010 to 2015. Then we had scientists, but now we have people who can make things happen even better than what we had in the late 60s. So that should ring a warning that we are not joking. 8 minutes mark in the flash. He said, "I do not believe in peaceful actualization of whatever rubbish is called. I have never seen where you will become free by peaceful means," unquote. The defendant also lent support for violent acts when he said he welcomed what a group known as Biafra Zionist group did when they unleashed violence at the Enugu State Government House. He even said he hoped more people will come out to join his group to overthrow the corrupt and inept persons in administration of the government, stating that Biafra must exist and it is their right to make sure it happens. In the broadcast of 16th May 2021, also contained in Exhibit PWW, the defendant in the beginning of the broadcast stated thus, "My name is Mazi Nnamdi Kanu. I am the leader of indigenous people of Biafra, IPOB, and director of Radio Biafra and Biafra Television. I will remain a loyal servant of the people of Biafra." He further stated around 51 minutes mark, and I quote, "If God is on our side, which I know he is, the army of Nigeria will die in Biafra land. Everybody will die. I will be the one leading it. By God's grace, everything called Nigeria will perish in Biafra land. The world must be prepared for what is to come. I want to let Katrina Lungs and the British government to know that we have chosen the path of death and people are dying every day. We have to develop the mindset of after this, which even though NATO is there, NATO is there. We say that we are ready to die, and everyone that comes to kill us will die also, because things will start happening in the next 14 days. In the next 2 weeks, the slaughter will begin to happen. You see those CNN that have refused to come to Biafra. We come by force to see what is happening. We will make sure that every Nigerian soldier on Biafra soil will die. God is my witness. I will lead this burial myself, unquote. Around 55 minutes mark to the exhibit, he said, and I quote, "I want the United Government to understand that we are ready to die than be slaves," unquote. At about 1 hour mark, he said, and I quote, "Israel was named Palestinians by the Romans because they were too stubborn. Go and ask how they did it. They bombed them, the Romans, away. Not these roadside bombs. Every road leading to Biafra will be man, landmine. Everything that is Nigeria, whether it is police, army, will blow till the kingdom come. Every neat and simple. Very neat and simple," unquote. The defendant also stated in that same broadcast, and I quote, "We are asking for our freedom, and they aren't listening. But when we start doing what we want, the whole world will start begging us, and then I will come out from wherever I am and tell them that it's too late. Throw away your phones. Remain incommunicado as we are in the state of war. It will not kill you to do away with your phones. All people should go into the bush and stop the advance of this army, or else they will kill you," unquote. These words spoken by the defendants in those broadcasts were not mere words, as they bear every traces of threats to harm people, including international representatives representing their nation in Nigeria. The said broadcasts were several in numbers, and the defendants kept repeating his rhetorics that people will die if Biafra is not created. The defendant planned to commit the terrorist act did not only manifest in his broadcast, but was shown in a meeting he had with other Igbo people in the United States. At a World Congress, Igbo Congress meeting held at the 4 Points Hotel in Los Angeles, in the United States of America, as contained in Exhibit PWW. The defendant, while speaking to the audience, stated, and I quote, "We must not miss this golden opportunity. We are bound to suffer in this time to come. You must come out to support what we are doing. We need guns and we need bullets. I know we love life so much. Without it, Hausa will overrun us. They have succeeded in imposing Okoroshan on us. They are coming. Boko Haram is coming in Igbo land," unquote. A female participant stood up to ask the defendant of his objective, as well as why need for weapons. The defendant responded, and I quote, "We now know that the best way to defend ourselves is to be armed, because Boko Haram is everywhere in Zoo, called Nigeria. So we need guns and bullets, and those of you in America will give it to us. Also, on the 22nd day of this month, something will happen called the blood moon. Most of you don't know that just before the Civil War, there was blood moon. There was blood moon in 67, and it only happens once in a while, because after this year, we will be free, no matter what happened. If we don't get Biafra, everyone will live to die. We are not joking," unquote. His intention was quite clear. He believes only in violence as the solution to the creation of Biafra as a nation. And at the said World Igbo Congress, most of the participants were quite alarmed by the expressions as is planned, and so they kept asking if he had considered the option of peaceful dialogue, to which the defendant was adamant that only violence could lead to the achievement of his aim. These threats of violence are nothing but terrorist acts, which was duly carried out by his followers, as will be seen later in this judgment. The defendant knew what he was doing while making these violent statements. He obviously had an objective, which one, the face of it is political. That is secession of the state of Southeast, South-South, and some middle belt states from the Federal Republic of Nigeria to form Biafra. The defendant was also bent on achieving his objective with the use of violence, and he didn't mind if his own people die in that process. As one of the crucial elements in establishing crime, the intention and the knowledge with which defendant carried out the acts can be expressed by him. If not so expressed, can be deduced from his conduct or activities or other connected circumstances. See Berede and Federal Republic of Nigeria. From the uncontroverted evidence led by the prosecution, particularly the broadcast contained in Exhibit PWW, it is clear that the defendant committed acts preparatory to and in furtherance of terrorist acts. The defendant had the opportunity to explain, but failed and deliberately refused to take that opportunity. Thus, he did not place any evidence before this court to explain the contents of the context of the state broadcast or any reason which may be exculpatory in his favor. Having failed and deliberately refused to enter defense or give explanation, the court will rely on the uncontroverted evidence of the prosecution. This court therefore holds that the prosecution has established count one of the charge beyond reasonable doubt. Consequently, the defendant is hereby convicted in respect of count one. With respect to count two of the charge, the defendant was charged with making a broadcast received and heard in Nigeria with intent to intimidate the population, issue deadly threats that anyone who flouts a sit-at-home order should write his will, as a result of which banks, schools, markets, shopping malls, fuel stations, domiciled in the eastern states of Nigeria were not opened for businesses. Citizens and vehicular movements in the eastern states of Nigeria were grounded. This offense is also punishable under Section 1(2)(b) of the Terrorism Prevention Act 20 Acts. The ingredients are similar as contained in count one, except that the prosecution must establish that the defendant indeed issued a threat to anyone who flouts his sit-at-home order in the southeastern state of Nigeria. The evidence as led by the prosecution shows that the defendant issued a sit-at-home order wherein he threatened the residents of the southeast states from going out. He further threatened that any church, markets, schools, banks, or shops which opened will be destroyed. This was the purpose of his broadcast of 30th day of May 2021. Where he stated that he had an announcement to make regarding the shutdown of the entire Southeast. He stated exactly at 9 minutes 10 seconds in the broadcast contained in Exhibit PWW, and I quote, "Tomorrow being the 31st day of May, there is complete lockdown, no church, no markets, and nobody should be seen outside tomorrow. I do not want violence. I do not want anybody to resort to violence. I condemn it completely and totally. We do not want to spill the blood of the innocent. Therefore, I am urging restraint across board. I am urging our people to honor the memory of people who died. There will be no school, no church, markets, banks, car on the roads. There will be complete shutdown. If you want to be alive, do not come out tomorrow. What I'm saying is that do not come out tomorrow. If you value your life, there will be complete shutdown of Biafra land tomorrow. Any community that allows vehicles to pass tomorrow will be in trouble. Anybody in any car or lorry except in ambulance will be in trouble. I know some people are very foolish, trying to open their shops around 12. If you open that very shop, we will burn you inside it. Especially Enugu, Umuahia, Abakaliki people. You are very stupid. Tomorrow, we will show you, unquote. This statement at first sounded peaceful and even seemed as if he was only persuading people to honor the memory of some people. However, the defendant, in his typical aggressive way of speaking, began issuing threats to those who might want to obey his order, that might not want to obey his order. The people of the Southeast are Nigerians, and I take judicial notice substantially are Christians who go to church, and merchants that are into trade, and their children who were threatened against going to church, their places of business and schools. This cause wonders if this can be said to be agitation for self-agitations. Unequivocally, I say no. The people of the southeast of Nigeria are entitled to their right to personal liberty, freedom of movement under Section 35 and Section 41 of the Constitution of the Federal Republic of Nigeria 1999 as amended. The said section provides, and I quote, "Every person shall be entitled to his personal liberty, and no person shall be deprived of such liberty, save in the following cases and in accordance with the procedure permitted by law. A. In execution of the sentence and order of court in respect of criminal offence of which he has been found guilty. B. By reason of his failure to comply with the order of court and in order to secure the fulfillment of any obligation imposed upon him by law. C. For the purpose of bringing him before a court in execution of order of court or upon reasonable suspicion of his having committed a criminal offence. D. In the case of a person who has not attained the age of 18 years for the purpose of his education or welfare. E. In the case of person suffering from infectious or contagious disease, person of unsound mind, person addicted to drugs or alcohol, vagrants for those people or purpose of those care or treatment or protection of community. F. For the purpose of preventing the unlawful entry of any person to Nigeria or of affecting the expulsion, extradition, or unlawful removal from Nigeria of any person or the taking of proceedings relating thereto. Provided that a person who is charged with an offence and who has been detained in lawful custody awaiting trial shall not continue to be kept in such detention for a period longer than the maximum period of imprisonment prescribed for him. Section 41 provides, every citizen is entitled to move freely throughout Nigeria, to reside in any part thereof, and no citizen of Nigeria shall be expelled from Nigeria or refuse entry thereby or exit therefore. They are also entitled, unquote, they are also entitled to their right to freedom of religion as expressed under Section 38 of the Constitution of the Federal Republic of Nigeria. The right to personal liberty, movement, religion are complementary of each other. Court jealously guides these rights, and they are basic rights which enough to them as being human beings. These rights are so fundamental. Kindly see, my Lord Agagu JCA has initiated on this in Okafo versus Lagos State Government and another citation supplied. The people of the Southeast cannot be ordered to sit at home by a person, especially for someone who is not a legally recognized official of the federal government or an official of any of the states. The only person entitled to restrict movements of persons within Nigeria is the President of the Federal Republic of Nigeria under emergency power under Section 305 of the Constitution of the Federal Republic of Nigeria 1999 as amended. The President can order for a coffee area where there is a crisis or natural disaster. The defendant is not the President of the Federal Republic of Nigeria, thus lacks any power to so declare a seat at home in any part of the country. The defendant arrogated to himself power he lacks, and with the threat of violence, order the residents of the southeastern states to stay at home or face the consequences of their disobedience. This is an unconstitutional act which is subversive and amounts to nothing more than a terrorist act. It is also a notorious fact that the people of Southeast have been subjected to sit-at-home threats on Mondays for years now. PW4, who stated that he was stationed in the Southeast, especially in Imo State for some years, gave evidence that Monday sit-at-home is a usual occurrence wherein the town are deserted, even the farmlands. PW4 also gave evidence on the death of one Ahmad Goodluck, a former aide to the former President Goodluck Jonathan, that the said Ahmed Goodluck had been killed by airport meant in pursuant to the order of defendants. Ahmad Goodluck was trying to catch a flight out of Owerri on the 30th day of May 2021 when he ran into a checkpoint by airport and was shot dead. PW4 stated that he was one of those who got to the scene first. It must be noted that 30th of May 2021 was a Sunday, not a Monday, but notwithstanding, it leads to the death of a person trying to move around due to the directive of the defendant as shown in Exhibit PWK. Is a medical report from the Nigerian Police Medical Services, Owerri. The report is dated 18th July 2021 and it states, to whom it may concern, medical report. Late Ahmed Goodluck Ahmed, hospital number. The victim allegedly shot dead by hoodlums suspected to be IPOB/ECN members on 30th October 2021 at about 7 hours along Airport Road, Owerri. Picture of lifeless man seen, body of deceased buried, information. The above medical reports, duly signed by the medical practitioner, clearly states the immediate cause of the death of Ahmed Goodluck and links him to the defendant as leader of IPOB and ECN. The action of the defendant cannot be excused under any circumstances. The declaration of a sit-at-home without any constitutional power, especially the accompanied by the threat, is a terrorist act. The defendant did not present any evidence to rebut this case, the case of the prosecution. Consequently, he admits the evidence as presented by the prosecution. The prosecution has successfully proved count 2 beyond reasonable doubt. Consequently, the defendant is hereby convicted of count 2. With respect to count 3, the defendant is charged with professing to be a member and leader of indigenous people of Biafra IPOB, a proscribed organization in which thereby committing an offense contrary to and punishable under Section 16 of the Terrorism Prevention Act 2013. Section 16 of the Terrorism and Prevention Amendment Act provides, and I quote, any person who is a member or professes to be a member of terrorist group commits an offense and is liable on conviction to imprisonment for a time not less than 21 years. The ingredients of the offense from the above provisions are: 1. The defendant must be a person. The defendant must be a member or professes to be a member of a terrorist group. 3. The terrorist group must have been proscribed as at the time the defendant professes membership of such group. As earlier established, defendant is compared to second ingredient, prosecution has led evidence showing that the defendant was not just a member, but he was the leader of a terrorist organization known as Indigenous People of Biafra. Indeed, in the broadcast of 16th May 2021, as contained in Exhibit PWW, the defendant, in the beginning of the clip, stated this, and I quote, "My name is Nnamdi Kanu. I am the leader of Indigenous People of Biafra and director of Radio Biafra, Biafra Television. I will remain a loyal servant of
Why
the people."
is the
Unquote.
judge trying to
He further
mimic the
stated
voice
around
of Nnamdi
51
Kanu while
minutes
he's reading, even when he
mark
wasn't
into the video.
eloquent in his reading?
He-
I'm quite
If God
certain
is
about
on
that.
our
The
side, which
judge
I
is
know
not
he is, the
eloquent
army of
speech.
Nigeria will die in Biafra land. Everybody will die. I will be the one leading it. By God's grace, everything called Nigeria will perish in Biafra land. The world must be prepared for what is to come. Unquote. In several other broadcasts,
Count
the
one and
defendant
count two.
admitted being the leader of indigenous people
Not
of
good.
Biafra. There is no fact before this court showing that defendant is not member and in fact leader of the said group. The defendant from the evidence before this court also possessed power to order the coordinator of IPOP in a broadcast dated 11th May 2021 in Exhibit PWW. The defendants, while commenting on the meeting of Southern governors held in Asaba, stated around 35 minutes to the exhibits. While played, and I quote, "Concerning the lockdown announced yesterday, I urge all people of Biafra and all those in Biafra land to disobey the lockdown given by Zoological Republic of Nigeria. The reason is because they want to use the dead of the night to move their fighters into our forest. Because we have defeated their foot soldiers. Mighty Allah, we must resist this stupid lockdown, and it will not hold in Biafra. I am calling on all the coordinators, deputy coordinator of ESN, and IPOB not to sleep in their houses today, but to look for somewhere else to stay. Because now we are in the trenches. Now you will know what is freedom fighting for. It is not comfortable. It is not rosy. Do not sleep at home. Do not sleep at home. Change your phone and even your phone itself. The defendant no doubt belongs to the group and belongs to the professing to be a member. He is a leader of the group with the influence of commanding the coordinators of the group. Not only IPOP, but even Eastern Security Network, which is the armed wing of IPOP. In the broadcast of 12th December 2020, the defendant made an announcement in inaugurating the military group known as Eastern Security Network, which is the armed wing of the indigenous people of Biafra. He stated, and I quote, "We have cowards, spineland idiots as governors. They have given over our land to the Janjaweed to occupy in perpetuity. This very generation, this very IPOB will not tolerate it. Not now, not tomorrow, not forever. We will rather all perish and die than to allow our land to be taken over by the Janjaweed. This is a warning to all the governors who are conspiring due to one political consideration to give our land to infidel and blood-sucking demons from this time. It cannot happen, not under our watch. We are being told that some of these invaders come from Senegambia, Mali, from Niger Republic, and some from Chad, according to Governor of Katsina State, El-Rufai. Therefore, we are setting up the Eastern Security Networks to combat the excesses of these vagabonds, criminals from crossing the Jail along the same line as Amotekun. the one set up by Metiala. What we are launching before the world today is Eastern Security Network, not a Biafra army, and we will let the world know when the army is to march. But for our present purposes, we are setting it up to defend our land, Biafra against Maronda from the Shahid and the Islam incursion led by terrorists, Fulani, to be precise. In the coming days, you shall see them in their uniform, performing the critical issue of providing security for our land, unquote. The defendants, who was visibly agitated, continue in the broadcast by stating, no governor in the Southeast and South-South have been able to form a security outfit. Therefore, IPOD must defend our land to the very last blood. We shall not stop, not now, not tomorrow, not forever, until our land is get rid of 20 of these Fulani terrorists. In the third video broadcast, there was a side video of the man of the Eastern Security Network, dressed in black with red cap, waving black flag with insignia of Eastern Security Network. This is therefore no doubt that the prosecution has established the second ingredient beyond reasonable doubt. With respect to the third ingredient, the evidence before this court shows that IPOP is a proscribed group. I take judicial notice of under section 122 of the Evidence Act of the order made by my learned brother Nyako J in suit number FAC/ABJ/CS/A71 between Attorney General of the Federation versus Indigenous People of Biafra, today dated 20th September 2017, wherein the activities of Indigenous People of Biafra were prescribed. The said order crystallized into PWJ, which is the Federal Republic of Nigeria Official Gazette number 99 in volume 104, dated 20th September 2017, titled Terrorism Prevention Order number Terrorism Prevention Order of 2017. The Gazette reads, and I quote, notice is hereby given that by the order of Federal High Court in suit number FAC/ABJ/CS/A71/2017, dated 20th September 2017, as per the schedule to this notice, the activities of Indigenous People of Biafra are declared to be terrorist and illegal in any part of the country, Nigeria, especially in the Southeast, South-South region of Nigeria, as prescribed pursuant to Section 2 of the Terrorism Prevention Act 2011 as amended. 2. Consequently, the general public is hereby warned that any person or group of persons participating in any manner whatsoever in any form of activities involving or concerning the prosecution of the collective intention or otherwise of the said group will be violating the provision of the Terrorism Prevention Act 2011 as amended and liable to prosecution.
I think if I review the count
The import
so
of the
far,
above is that beginning from the commencement
this
date
judgment
of
might have wider implication
20th
for
September
any
2017,
IPOB members,
person claiming to
especially
be
those in the diaspora.
a member
We
of
would
IPOP
look at the
commits
legal
a terrorist act. The defendant by his broadcast of
affirmation
11th May
and legal
2021,
explanation to it
12
later.
December 2020, professed to be a member of proscribed group.
Please,
Thus,
those of
he is
us in the
breach
comment
of
section, can we keep
Section
it civil,
16(1)
please?
of the Terrorism Prevention Amendment Act 2013. Consequently, he is hereby convicted of count 3. On count 4 and 5, which are closely related. The defendant is charged with inciting members of the public in Nigeria to hurt and kill Nigeria security personnel and their family members,
Convicted on
thereby
count 1,
committing
2, 3.
offense under Section 1, Sub 2H of the Terrorism Prevention Amendment Act 2013. The section provides as follows: any person or body corporate who knowingly in or outside Nigeria, direct or indirectly, willingly incites, promises, or induces any other person by any means whatsoever to commit the act of terrorism, or any of the offenses referred to in the act, commits an offense under the act
Do not,
and is liable to
if these convictions stand, if that was not removed from the Court of Appeal, my estimation is that those, those who identify themselves as IPOB members within and outside Nigeria may also have
directly
cases
or
to answer.
indirectly incites, promise, or
That means if the state
induce
decides
other
to.
person by any
So
means
for some of you
whatsoever
who
to
do
commit
not
the
hold the
Terrorism Act.
passports of
3.
some of
The
your
defendant
nations
must
that
have
where you are
directly or
resident in,
indirectly incited,
you
promise,
may
or
have to be
induce
careful
other person
at,
by any means whatsoever to commit the
whatever you
Terrorism
do.
Act
There might
willingly
be
or
consequences.
knowingly. The defendants have been established to be a human being by the prosecution.
And by this,
But the second
what the
ingredient
judge
is
has also done
important
is
to
to
understand what
re-establish
incitement
and,
means. According to Supreme
indirectly
Court
reaffirming
Nikitovic,
the
DSC of
gazettes that
Blessed Memory,
IPOB,
in
or
CASA
rather
and
the
the state
prescription,
citation supplied,
in this case,
hold, and I quote, an
it brings
encouragement
that
here
back to the
means
fore that,
an act of making someone to
if
feel
these
brave
count,
or
now we
confident enough
had
to do
count
something
1,
by
count 2,
giving
and count
active
3,
approval
and in this convicted,
in
if
support
these
of the crime.
count stands, that
Incitement
means
also have the element of encouragement. By incitement, the
be
person is
careful.
provoked
This is
by
not
a
about
strong
emotion.
passion or feeling to commit an offense. The word set is a word of quite a number of synonyms. The two words set on connotes the resemblance of causing to attack or chase, like one may be, say, the fisherman prepare the bait to set on the fish. It also has the element of antagonism and instigation. The act of instigating means something happened by the actions or conduct of a person who is the starter. By the act of instigation, the co-accused is prepared or gingered to commit an offense, unquote. Likewise, the online Oxford Dictionary defines incitement as follows: the action of provoking unlawful behavior, urging someone to behave unlawfully, unquote. The Cambridge Dictionary also defines incitement as follows, and I quote: the act of encouraging someone to do or to feel something unpleasant or violent, unquote. Drawing from the above definitions, the incitements involve provoking or instigating people to do an unlawful act, and in their instant terrorist acts. The prosecution has led evidence showing that the defendants made broadcasts inciting public to take up arms against the security personnel in Nigeria to kill them and their family members. The broadcast of 21st day of October 2020, as contained in the PWW, the defendants said, and I quote, Radio Biafra is now in the hand of the enemy of our freedom. I don't know how much they paid for it, but I know that Britain spent over 4.8 billion a few days ago to suppress what is happening. That is what they have done. I told you a while back that Britain was now in charge of what is happening in the zoo, and you thought that I was joking. They have now come with their clamp down, but they are now going. They are not going to succeed. Radio Biafra belongs to us, but Why is it not playing out our program right now, unquote. The defendant also stated, I am telling you people to go to the bush whenever you see a military convoy. You attack them. Whenever you see a police convoy, attack them. They are human beings and they also bleed. Any person with a police uniform or any army in any army uniform is an enemy of the people, unquote. Around 57 minutes to this video mark, the defendant stated, and I quote, they came to Tinubu. It is surprised that after British High Commissioner came to Tinubu, they opened fire on protesters in Lagos. You should know, you should not by chalk that the woman is a devil, a big devil. She too will go, will get a comeuppance, unquote. The defendant was referring to Katrina Link, the British High Commissioner at that time. The defendant also said, from what will happen in Aba between today and tomorrow, we tell you how serious we are. Every police officer with uniform, once you come out from your house with police uniform, you are dead man walking, unquote. Callers were calling in from places like Aba, like toll gates and other parts of Lagos, Ibadan, Abuja, Jos, Abia State. Even one Jacob called from Nasarawa State. And the defendants kept giving orders for these callers and other listeners to kill every police and soldiers. The defendant even told the people how to build an improvised bomb. He asked them to go to a filling station to get fuel in a bottle and put a rag in it. Then they should set the rag ablaze and hold it at soldiers. In responding to a caller call from Abuja, in that same broadcast of 20th October 2021, the defendant, while inciting his listener to attack the relative or security personnel, stated, and I quote, that every commander they have given his name, find his children. I want to get him in trouble. When they take me to court and ask why I said such thing, I will tell them why. Find the commander. His name is Ifu Umata. Find his children. Find his children. The commander of those on the ground. Find their children. Very, very important. Find their children. Unquote. The defendants went for that. And I quote, start attacking the police. Take their guns. Use them against them. Manufacture motor tours, cocktail. Manufacture bombs to bomb them. Unquote. The defendant at about 2 hours, 44 minutes, 35 second mark, while concurring with a caller who informed him of the intention of him, other IPOB members, to burn down the Ezima police station, stated, not only one, I want every police station in Aba to be destroyed, completely destroyed, and burn them down. It is an order destroying them completely. Anybody who sees them with police uniform, kill the person. Nigeria wants anarchy. We will give them anarchy. In another broadcast, the defendant, while responding to a caller, stated this: you people must devise strategy to outfit the army. There are some guns in Edo State right now, as we speak. Use those guns to kill 1 or 2 of their army officers. Take their guns and begin to kill other people as well, because they cannot sustain this protest for 3 weeks. There are guns in Edo State already. Kill the army whenever you see them. Take their guns and kill them. Unquote. The incitement of the defendant for the public to kill security personnel is quite clear from his big blockers. Not only incitement to kill, security officers. The defendant even went as far as inciting the public to destroy all properties of federal government during the NSAS protest of 20th October 2020. The defendant, in another live video dated 20th October 2020, the defendant, while responding to calls from his foot soldier during the NSAS protest, stated, and I quote, "If you leave the Janjaweed and their agents the way they operate, if you leave them, believe believe me, you will suffer. That very hotel must be brought down. I did not say set ablaze. It must be demolished. As an example to the rest, if you have not dealt with Tinubu in Lagos, the other will not learn their lesson. Tinubu is an evil man." The hotel referred here to is Oriental Hotel in Lagos, which the defendants alleged belonged to Tinubu. While responding to a caller, the defendant urged his callers to ambush the security forces during the protest and cut them off. He said, and I quote, "Go to the bush. You need to cut them off from the back, ambush them, take their guns from them and kill them. They are animals and not human beings. They may be wearing uniform like police or soldier, but they are animals. Disarm them and kill them. If you allow them to escape, your life is over. And I want Lagos airport to be on flame. Breached the perimeter fence and burn down the Lagos airport. If you have double barrel or pistol, go to the airport and burn it down. Set Muritala Muhammad airport on fire. Set it ablaze right now. You are dealing with animals. Fulani Janjawi. They do not reason." Unquote. It is important to state that the said hotels and Muritala Muhammad airport and other property in Lagos, they are not in the north, where it seems to hate with passion. Even his own fellow Igbos people have property in Lagos. With destroying the property is said to be agitation for self-determinations. The threats and destruction which follow were corroborated in Exhibit PWD2, which is a pictorial pictures of the assessment of damage done to the Nigerian police alone in the state of southern states. So many of these police stations and even police officers were killed as a result of the incitement by the defendant. Also, Exhibit PWD2A, which is a compilation of death reports and certificates of death of security officers in the report. The number of police officers who were killed was given as 128. Military officers were 37. Other security officers as 10. Number of police stations attacked were 164. INEC facilities destroyed were 9 in number. This clearly shows the extent of damage caused by the defendants through his inciting statements. Another caller called into the program informing the defendant that he was at Oshodi Apapa Expressway and that they are killing them. The defendant, annoyed by this information, stated for, and I quote, "How many police or army did you kill? I don't want to hear that. They are killing you. How many did you kill?" Unquote. The caller then responded that they have burnt the Orile police stations and Ilasa police station. The defendant then told the caller not to wave the green, white, green flag of Nigeria, but a blood-stained flag with the color green, white, red. He further responded to another caller by saying, "What I want them to do is to set ablaze the United building along Marina on fire. Every federal government property in Lagos should be burnt. That is what is going to be signaled to the world that people have had enough. I want every federal government building in Lagos to be on fire. Every federal government vehicle or anything belonging to federal government, burn it. Go to the Muritale Mwane airport, burn it. How many soldiers do they have? Manufacture your own weapons and ambush them, unquote. The result of this incitement is the killing of several military officers, police officers, DSS officers. The incitement also led to the destruction of several police stations in Lagos across the southern states of Nigeria. According to PW5, he led a team of officers to investigate the destructions and killing of the security personnel that occurred during the NSAS protest of 20th October 2020, as contained in Exhibit PWD2 and Exhibit PWD2A. The results were quite alarming. The court is mindful not to attribute all the happening during the NSAS protest on the defendant. However, there is no doubt that the incitement by the defendant contributed largely to the killing of security operatives, as well as destruction of public properties. The defendant incited people to destroy property such as the Lassa police station, other police stations, and properties of the government. The evidence before this court shows that the said properties were actually destroyed, such as the Lassa police stations, the High Court of Lagos in Igoshere, as well as PRT buses belonging to Lagos State government in Oyinbo. PW2 also testified that military corpus were killed by those incited by the defendant in Olu in Imo State. In addition, PW4 stated that his driver and one of his tactical officers were killed as a result of the incitement. The action of the defendants were clear, as it was aimed to cause anarchy by killing security operatives in Nigeria, which would in turn lead to breakdown of law and order. The defendant had an evil intention to wreak havoc on the people and government of Nigeria. Are all these actions consistent with agitation for self-determination? The answer to this is in negative. His violent outbursts, as well as his instigations of the public to attack and kill security officers in southern Nigeria without provocation, was downright barbaric and without any conscience whatsoever. The defendant did not feel any concern for the family of the officers who were slain. He turned himself to a tyrant who could take life anytime he pleased. Such persons cannot be allowed to remain in society of sane minds. His shocking instigations to kill other human beings was incomprehensible, and this court hereby condemned it. But I must say that the evidence extracted is minute compared to the avalanche of. I must say that evidence extracted in this judgment is minute and very small to the avalanche of evidence and broadcast before these courts by the defendant. The defendant made extremely threatening statements, incited people to violence. The prosecution has successfully discharged his burden of proving counts 4 and 5 beyond reasonable doubt. Consequently, the defendant is hereby convicted of the said counts 4 and 5. Now, count 6. For count 6, the defendant is charged with the offense of making a broadcast received and heard in Nigeria within the jurisdiction of this court, in furtherance of an act of terrorism against the Federal Republic of Nigeria and the people of Nigeria.
Nnamdi Kanu has been convicted on count 1, 2, 3, 4, and 5.
To manufacture bombs,
What?
thereby committing an offense punishable under Section 1, 2F of the Terrorism Prevention Amendment Act 2013. Section 1, 2F of the Terrorism Prevention Act 2013 provides: 2. A person or body corporate who knowingly in or outside Nigeria directly or indirectly, willingly, F, assists, facilitates, organizes, or directs the activities of person, organization engaged in any act of terrorism. The ingredients of the offense expected to be established are: 1, the defendant must be a person or body corporate. 2, the defendant must have assisted, facilitated, organized, or directed the activities of person or organization engaged in terrorist activities. 3, the defendant must have willingly or willingly assisted, facilitated, organized, or directed the activities of persons, organizations engaged in terrorist acts. The defendants herein have been established to be a human being. As to the second and third ingredient, the prosecution has led evidence to show that the defendant has directed members of the terrorist organization to build bombs, other explosives in order to attack security operative. Indeed, in furtherance of its terrorist actions and following the incitement of persons to kill defendant to security operative, the defendant also directed his members to build explosive devices, particularly Omotosho cocktail. At about 1 hour, 30 minutes, 36 seconds of the broadcast of 20th October 2020, as contained in Exhibit PWW, the defendant, while responding to a caller about ENSA's protest, stated, and I quote, "Now, this night, I want graduates to go to work, graduates of chemical engineering, those who were born as engineers, manufacture any ordnance you can, because they are coming to kill you anyway, regardless of what you do. Go and manufacture any ordnance. I am calling on the youth in the middle belt, and I want any bridge that they can use to reinforce to be destroyed. They are going to come from the middle belt. This night, we have engineers everywhere, people who are intelligent. Go back now and give us your own version of Omotosho cocktail. We must destroy them before they destroy us. Every youth tonight, anybody with a police uniform, anywhere, especially in Aba, in Lagos, once you have police uniform or any army uniform, that person is your enemy. Attack them, because if you don't, they will kill you. If you are a graduate of physics or chemistry, no sleep for you tonight. Go and manufacture something to destroy the police and every army police position starting from this night." Unquote. During the said broadcast, while responding to a caller named Jacob from Nasarawa State, the defendant even told the people how to build an improvised bomb. He asked them to go to a filling station to get fuel in a bottle, put a rag in it, that then they should set the rag aflame and hurt it at a soldier. A Omotosho cocktail, according to Wikipedia.com, that I accessed at 1 a.m. on 20th November 2025, is a hand-drawn incendiary weapon consisting of a fragile container filled with flammable substances, equipped with a fuse. In use, the fuse attached to the container is lit, and the weapon is thrown, scattering on impact. Unquote. The online Britannica dictionary defines Molotov cocktails as a crude bomb, typically consisting of bottle filled with inflammable liquid and a wick that is ignited before throwing. Unquote. Applying the above definition, the directive of the defendant to members of the group to build improvised bombs such as Molotov cocktail is indeed a terrorist act. A Molotov cocktail is capable of causing explosions, damage like any other bombs, which aim is to cause destructions.
I don't understand why.
Directive, like all that directive, is a manifestation.
I don't understand why that word is
anarchy-minded
so hard to pronounce, even when you've done it 1, 2, 3, 4, 5, so you keep making the same mistake.
Anarchy-minded
Come
of
on.
the defendant, which is set out to express through his Biafra radio, which he claimed to be the founder and director. The defendant, through the radio Biafra platform, carried out so many terrorist attacks, which led to the destruction of lives and property in Nigeria. The defendant is not only confirmed to local terrorists, but I oath without hesitation that he is an international terrorist, flowing from his threats to attack British High Commission and the American Embassy, as well as his incitement against the British High Commissioner to Nigeria at the time, Catherine Lyons, a known woman of peace. In a broadcast of 21st October 2020, the defendant stated thus, and I quote, "Radio Biafra is now in the hand of the enemy of our freedom. I don't know how much they paid for it, but I know that Britain spent about 4.8 billion a few days ago to support what is happening. That is what they have done. I told you a while back that Britain was now in charge of what is happening in the zoo, and you thought that it was a joke. They have now come with their clampdown, but they are not going to succeed. Radio Biafra belongs to us, but why is it not playing our program right now?" Unquote. The defendant also stated, "I am telling you people to go to the bush. Wherever you see a military convoy, you attack them. Whenever you see a police convoy, attack them. They are human beings, and they also bleed. Any person with a police uniform or any army uniform is your enemy." Around 57 minutes mark into that video, the defendant directed his threat at Catherine Lyons, the British High Commissioner. He stated, and I quote, "They came to Tinubu. It is a surprise that after the British Commissioner came to Tinubu, they opened fire on protesters in Lagos. You should not be shocked. The woman is demon, a big demon. She too will go come repentance." Around 1 hour, 8 minutes, 35 second mark, the defendant also stated, and I quote, the same thing that Britain did to Biafra in what they are doing to us now, media blackout. Do you want the world to report this issue? Take over the British High Commission. That is all. Take over the consulate in Lagos. Take over the one in Abuja. Every newspaper in the world will report it in the morning. If you march on the British High Commission in morning, front pages in the world will carry it, and the world will ask why is British Commission in Abuja and Lagos under occupation by Nigerian youth. Then it is over. I'm giving you a master strategy of how you should be done. In a formation of 3 lines, there is something I want you to do. I'm announcing it on air so you understand. People should go to every weather shop around you. You know those who build bullet-proof door. I don't care how much it costs. We will pay. Everybody who is a welder, who builds bulletproof, people should take those doors and put nails in front of them and stand in front of protesters so that bullets cannot go through. Push the door, get the weapons, and deal with them. When you are marching to the British High Commission tomorrow, form 3 lines. They will have the army surrounding them. They will send a cable to London that British High Commission in Lagos is under attack. They will be forced to release it. Then the whole world will know that a revolution is going on. Without that, you cannot succeed, unquote. Even recently, in this courtroom, on the 7th day of November 2025, when the matter came up before this court, the court wondered the kind of malice and hatred which the defendant had for Britain. I will produce same parts of the proceedings of that day here too. Defendant, he says, there are issues at play which my Lord has not able to overcome, which even the prosecution has not even attempted to overcome. My Lord, are you asking me to go into the doors to defend myself on a non-existing law? If you can state that for the record, my Lord, I will be most grateful that you are going to try me or ask me to enter my defense where no law exists. Because if that is the position, my Lord, that means that the outcome of very trial is predetermined. A man of my station and caliber cannot be tried without any valid law. It is impossible, my Lord. I will tell you why. This was the case. This very case is bigger than this court. The case of mine started in 1957, when some brave men and women in this very country dared to ask the British to leave. The funniest thing is that all of them that pioneered that very effort, they all went to jail and were killed. Court, I'm learning this now. Then ask the British to leave. Defendants, yes, in 1957, Dr. Anthony Nao moved a motion at the House in Lagos, asking the white men to go and leave us alone. From that day, trouble started. Even before then, the like of Abat Macaulay was jailed, honorable men that fought for the indignity of the black race because they want me convicted. They told me so. Absolutely, my Lord. Absolutely, 100%. They told me. They said, I will come to court to see, to hear your case. When you take your plea, when persecution opens, then their case, when prosecution
or
opens
prosecution.
their case,
I mean,
when you start your cross-examination,
Edo people, pardon me, but this
when
is
they
sounding
retrieve
like your
no
governor
case
now.
submission,
Sorry.
I am telling you what
It's like your
happened
governor when
a
he's
year
reading
and
budget.
half ago, when you file your no case submission and is rejected, you will not go into trial. You will be there during the verdict. You will be there during convictions. The court now responded. Let me just clarify this. It is also on record. You said that the British said that 1 year and a half ago that I was not the one presiding here. I want to say this, that I know my brother too, that was asserting it will not get into that level of having anything to do, anything, because the way you are putting it. I want to say this. I do not have any relationship with the British. I have come here to do justice. I reiterate. Can you commence your defense so that if you commence today, I can extend time for you because your time has ended today. For the U.S. Embassy, it would have been attacked if not for the closure as a result of the protest. The defendant at about 2 hours, 24 minutes, 50 seconds, mark of the video of 21st day of October 2020 broadcast in Exhibit PWW stated, American embassy is shut down. Why won't they shut down? People are protesting. This statement regarding the embassy of United States of America is quite loaded. The statement could mean several things, none which are palatable or peaceful. What exactly does the defendant mean by the American embassy is shut down? Was he trying to attack the embassy if it has not shut down as a result of protest, or incite others to do same, as he did in British embassy? The inference to be drawn from the statement is that the defendant meant to do harm to the embassy of the United States by attacking or invading the embassy. Under international law, the premises of an embassy or high commission of a foreign nation is deemed inviolable. That means that even though the land belongs to host country, it cannot invade such premises. See Article 22 of Vienna Convention on Diplomatic Relationship, Article 22 of Vienna Convention on Diplomatic Relations, 1961. It provides thus: the premises of missions shall be inviolable. The agent of the receiving state may not enter them, except with the consent of the head of the mission. 2. The receiving state is under special duty to take all appropriate steps to protect the premises of the mission against any intrusion or damage, and to prevent any disturbance of the peace of the mission or impairment of its dignity. 3. The premises of the mission, their furnishings, and other properties thereon, and the means of transport of the mission shall be immune from search, requisitions, attachment, or execution, unquote. Thus, from the above, it can be said that the defendant incited for people to invade British High Commission and his threat against British High Commissioner Catherine Lyons and American Embassy is an act of international terrorism. This is the purpose of Section 3 of the Terrorism Prevention Amendment Act 2013, which provides, and I quote, any person who intentionally murder, kidnap, commits other attacks on persons or liberty of an international protected persons. B, carries out violent attack on official premises, private accommodation, or means of transport of an international protected person in a manner likely to endanger his person or liberty. C, threatening to commit any such attack, commit an offense, and is liable on conviction to life imprisonment. The High Commissioner is an international protected person, being the representative of the British government in Nigeria, as well as other staff of High Commission and Embassy of the United States of America, leaving the defendant to continue his terrorist activity who have led to an international incident involving Nigeria and other foreign nations who are good partners with Nigeria. The question to ask again is whether bombing or attacking embassies of high commissions constitutes an act consistent with agitation for self-determination. Again, the answer is no. All these acts goes to show that the criminal tendency of the defendant, as well as show concrete proof of his terrorist acts. Therefore, I hold without hesitation that the prosecution as successfully established can cease against the defendant. Consequently, he is hereby convicted of count 6 of the charge. With respect to count 7 of the charge,
Count 6.
the defendant is charged with importing into Nigeria and keeping in Ubuluzo in Ihiala, local government of Anambra State, within jurisdiction of this honorable court, a radio transmitter known as Tram 50 concealed in a container of used household items which he declared as used household items. thereby committing an offense contrary to Section 47(2)(a) of Custom and Excise Management Act, Cap C-45, Laws of the Federation of Nigeria, 2004. The dispute as to which law provides for the offense in Count 7 has been conclusively decided by the Supreme Court in case of Federal Republic of Nigeria versus Kanu Supra, where my Lord M.L. Gaba, JSC, while reading the lead judgment, aired, and I quote, "A calm reading of the details of the facts stated as constituting the offense mentioned or named therein would clearly and undoubtedly reveal that it deals with the offense punishable under the provision of Section 47(2)(a) of the Custom, Excise and Management Act, Cap C-45, Laws of Federation of Nigeria, 2004, which provides as follows: 47(2). If a person A imports or causes to be imported any goods concealed in a container holding goods of different descriptions, or he shall be sentenced to imprisonment for 5 years without the option of fine. It follows, in the above circumstances, that the mention of the Criminal Code Act as being Chapter C-45 or Chapter C-45 in Laws of Federation of Nigeria, 2004, is a mere mistake in place of correct law. The Customs and Excise Management Act, under which the facts alleged to constitute an offense in Count 15, is punished and punishable. The offense in Count 15 is consequently recognizable and grounded in an extant existing law in Nigeria in which it was defined and described, unquote. Thus, the court will follow the decision of the Supreme Court and decide Count 7 based on Section 47 of the Custom and Excise Management Act. The ingredients of the offense are: the defendant must have imported or caused to be imported goods concealed in a container. 2, the imported concealed goods must have been of a different descriptions. The evidence led by the prosecution through PW4 is that the defendant imported into Nigeria a radio transmitter known as Tram 550L concealed in container which contain used household items which he described as such. PW4 stated that indeed the Department of State Service had tracked the transmitter of Radio Biafra to a compound in Umuluzino in Ihiala, local government of Anambra State, belonging to one Benjamin Madubulu. The officer secured a search warrant, exhibit PWT, and proceeded to the compound where they recovered the container. Prior to going to the scene, PW4 testified that he watched a video of the defendant inspecting the container and the transmitter with Benjamin Modubugu. The court visited where the container was kept in the custody of the DSS, and same was admitted in evidence in the presence of the defendant as exhibit PWY, and he did not object to same. The container itself contains several household items which appear to be covered for the transmitter concealed in it. The prosecution has led evidence to show that the transmitter was smuggled into the country without same being declared to custom. That the cover of the household item was used to disguise its true content. The surrounding facts also show that the purpose for which the defendant intended to use the transmitter was to broadcast program on Radio Biafra, and this makes it concealed the transmitter. This is also not. There is also no evidence that Radio Biafra is registered with the Nigeria Broadcasting Commission as stated by PW4. Thus, it is safe to conclude that the concealment of transmitter is in furtherance of the illegal operation of Radio Biafra by the defendants. The defendants, as a consequence of resting his case on the prosecution, did not call any witness to report the evidence of the prosecution, neither did he lead any evidence to counter the evidence of the prosecution. There is no evidence before this court stating the transmitter was lawfully imported into Nigeria. The defendant had the duty to present evidence and failed to report the allegation made against him. But he failed and deliberately refused to do same. The court is therefore bound to believe the evidence of the prosecution. Consequently, the court hereby convicts the defendant of count 7 of the charge. I must say here that defendants have always claimed to be a freedom fighter. He is only seeking justice for his people. Indeed, this is known in law as the right to self-determination. The right to self-determination is a political right recognized in several international instruments. Article 1 of the International Convention on Civil and Political Rights, 1966, provides, and I quote, "All people have the right of self-determination. By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural developments." Unquote. The right to self-determination also entails the right of a group of people to form their political entity or their own governments. Article 20 of the African Charter on Women and People's Rights also provides, and I quote, "All people shall have the right to existence. They shall have the unquestionable and inalienable right to self-determination. They shall freely determine their political status and shall pursue their economic and social development according to the policy they have freely chosen." 2. Colonized or oppressed people shall have the right to free themselves from the bond of domination by resorting to any means recognized by the international community. 3. All people shall have the right to the assistance of the state parties to the present charter in their liberation struggle against foreign domination, be it political, economic, or cultural. Unquote. Nigeria has domesticated the African Charter, which is known as the African Charter on Women and People's Rights, Ratification and Enforcement Rights, which means the provisions of the Charter are enforceable in Nigeria, provided they do not conflict with the clear provision of the Constitution of the Federal Republic of Nigeria 1999 as amended. Section 2(1) of the Constitution of the Federal Republic of Nigeria 1999 as amended makes it clear that Nigeria is an indivisible state, which means there is no room for divisions. The said section provides, and I quote, "Nigeria is one indivisible, indissoluble sovereign state to be known by the name Federal Republic of Nigeria," unquote. This means that anyone agitating for a breakup of the Federation of Nigeria is going against the Constitution. However, any person agitating for self-determination can do so through the National Assembly seeking for amendments of the Constitution regarding the indivisibility of Nigeria and to reflect the recognition of the agitating states. It is after this that the procedure can be said to be completed, but not excluding a referendum. Any self-determination not done in accordance with the Constitution and laws of the country will be illegal. The defendant is not only agitating for secession of the state of the Southeast, South, and some Middle Belt states. He is doing so using terrorism as a weapon. Terrorism has become a monster in the world today, and several groups have continued to use this weapon to form separate governments. In Nigeria, groups like Boko Haram, Lakurawa, IPOP have in recent years troubled Nigeria with terrorist activities. This terror group, by their activities, has denied innocent people the enjoyment of their fundamental rights. The action of the defendant and his terrorist organization have led to the bloodshed of innocent citizens, as well as security personnel who were going about their legitimate duty. His incitement through the broadcast on Radio Biafra as well as the social media platform of the group has led to the destruction of lives and property, as well as affect the daily life of his people of Southeast. The defendant did not only threaten the government of Nigeria, but his own people. This is seen in a broadcast while addressing the death of one of the commander of IPOB, named Ikozo. The defendant on 25th day of April 2021 made a broadcast where he stated, and I quote, Ikozo was not killed on the battlefield, but was killed in his village in the middle of night. Not on the battlefield because
Ikonso,
battlefield,
not Ikozo.
no army or police can defeat him. Ever since Eastern Security Network was launched, I have not seen anybody tell me that their life have not improved since it was launched. Around 21 minutes marked, the defendant stated, vengeance is a monster of appetite, forever blood-tasty, never filled. Ikozo is in heaven. He is going to be revenged, and by God, he will be revenged. All those who had hand in Ikozo death are all dead. People walking, all of them. He also stated that Ikozo will be mourned in a special way, just like how the Oba of Bini is buried with human heads. That they said Ikozo is more than Nanoba.
Up Nepa.
Thank you.
Up Nepa in the court.
There is no doubt that this is contained in the broadcast. The defendant's statement was corroborated by PW4, who stated that upon the arrest of one of the IPOB commander named as Onyem Army, he informed them that they were only to get 30 heads of women out of 2,000 heads of as ordered by the defendant. This court is aware that the said Onye Army was not caught as a witness in this case, and this may affect the probative value of his evidence. However, the evidence being used, this evidence is being used as corroboration to the statement made by the defendant himself, admitted by the statement of, and is admitted as a defendant for that purpose. Corroboration referred to supporting or additional piece of evidence that supports another evidence. See Ogunbayo and the state citation supplied, where the Supreme Court held, and I quote, corroboration having been held not to be a technical terms of all, means no more than evidence tending to confirm, support, and strengthen other evidence sought to be corroborated. This evidence is to corroborate the evidence, the statement of the defendants. I must say here that the prosecution witnesses were consistent and calm in the giving of the evidence. Their calm demeanor, despite provocative questions under cross-examination, shows that them to be witness of truth. I carefully observed them, and the only conclusion to reach is that they are witness of truth. And this court readily believe them. The defendant, on the other side, from his attitude in court, was truly very cocky, arrogant. He even stated that no court can convict him. This is a direct affront on the power of the courts, which this court will not take for granted, but will do justice. It is interesting to note that the defendant, who claimed to be a freedom fighter, has even caused more harm to his own people, who are predominantly Christian faiths. Can this be said to be agitation for self-determination? Not at all. Agitation for self-determination cannot be to the detriment or to be detrimental to people who are supposed to be beneficiary of that self-determination. The usual sit-at-home order primarily affects his own people of the Southeast. The killing of people who disobeyed the order are his own people. Ordering of closure of churches and schools as well as markets also affects his own people. They are unable to trade, go to school, farm, even worship on such days. The threats of violence and death have prevented these people from going about their legitimate businesses. Are these acts of the defendants consistent with the agitation for self-determination? The answer is in the negative once again. The defendant was not elected by anybody, also cannot dictate for the people of Southeast, especially through intimidation and threats of violence. He is a terrorist. He must be treated as such. In final analysis, the prosecution has successfully established the 7-count charge against the defendant beyond reasonable doubt. Consequently, he is convicted on all the 7 counts.
Jesus. Verdict
By
now.
the time the next just 30 minutes, I go to the chambers. Anybody is free to come and get a certified true copy of the judgment.
As the court pleases,
The minute I get to the chambers, the next 30 minutes, it will be signed.
Thank you, my lord. May I
Jesus.
invite your lordship's
Been
attention to the
convicted in all
title
the 7.
of this case. It is Federal Republic of Nigeria versus Nnamdi Kanu.
I'm coming, sir.
So in this case, when is the pronouncement going to be made? I mean, how long since he's been convicted in all 7 charges? Some of them carry
My lord, the people,
life
200
imprisonment, some
million
of them
people
carry
of
5 years.
Federal
So how is
Republic
it?
of Nigeria have brought Nnamdi Kanu before this court for acts of terrorism. And my lord, in the last few weeks or last few days, Nigeria has been a season of victims of and are victims of terrorism. But my lord, this afternoon, this honorable court delivered its judgment in which the convict Nnamdi Kanu was found guilty and convicted of offenses under Terrorism Prevention and Prohibition Act. He has accordingly been convicted, and it is now to be sentenced.
Okay.
My lord, the prosecutor has a duty to invite your lordship's attention to a few points that with judgment just delivered, this court
Sentence.
has again affirmed the long-standing principle that whenever Nigeria as a
Convicted on
nation
7 counts.
is confronted with moments, actions, and events that pose grave danger to its existence, independence, and unity, the judiciary stands firm at the stabilizing force of the country, guided by the wisdom, courage, and integrity of judges who serve within that arm of government. Terrorism, my lord, remains one of the gravest threats to humanity. It is among the most devastating of atrocities in human history. As the leader of the proscribed indigenous people of Biafra, the convict, through his broadcast on Radio Biafra and through the group Armed Wing, the Eastern Security Network, repeatedly attacked Nigeria and took active steps to desegregate the country. By the conviction of Nnamdi Kanu for acts of terrorism, it is clear that justice has been served to the thousands of innocent Nigerians who lost their lives as a result of the inciting broadcast and violent activities of Eastern Security Network. The blood of those who have died cries to heaven, and God in his mercy has given them justice. Justice has honored their cry. The families of more than 75 security officers who were murdered in the service of their fatherland will now find some comfort in this conviction. Those whose relatives were brutally killed and buried with Ikonso of the order of the convict here have not died in vain because justice has been done. My Lord, the record before these courts are replete with the losses suffered by citizens of Nigeria residing in the interstates of the Federation, citizens who, through no fault of their own, were forced to live in fear, had their businesses destroyed, and were reduced to paupers as a result of stay-at-home orders issued by the convict and violently enforced by the commanders of the ESN. Justice has today set them free from oppression and economic strangulation caused by the terrorist activities of the convict. The convict now knows that the law is greater than any individual. Therefore, justice has been done to him too, and that Nigeria has both the power and the capacity to punish anyone who, through deliberate, reckless acts of terrorism, seeks to divide the country by attempting to create the so-called Republic of Biafra by force out of the Federal Republic of Nigeria. My Lord, consequent upon the conviction, as nothing further remains but the lawful imposition of sentence, the punishment prescribed for the offenses in counts 1, 2, 4, 5, and 6 is death penalty.
What?
Pursuant to Section 1(2)(h) of the Terrorism Prevention Amendment Act 2013, my Lord, with all sense of humility, I say, sir, as a prosecutor, that this court has no discretion in that regard, and that the only sentence that your Lordship will impose for counts 1, 2, 4, 5, and 6 is death sentence. The court, this court has the power to do so, and with respect
1,
must
2,
do
4,
so.
5, 6. 1, 2,
The
4,
language
5,
of the
6.
act is clear, and the court is urged to apply it strictly without deviation. For the offense under count 3, relating to membership of IPOB, a proscribed terrorist organization, the punishment is imprisonment for a term of not less than 20 years, in accordance with Section 16(3) of the Terrorism Prevention Amendment Act 2013. We urge your Lordship, in accordance to death sentence, to also pronounce and impose the sentence as prescribed by law, having found him guilty and convicted. For the offense under count 7, the punishment is 5 years imprisonment without the option of a fine, pursuant to Section 46 and 47 of the Custom and Excise Management Act, C-45 Laws of Federation. In sentencing, this honorable court is obliged to consider the nature and gravity of the acts of terrorism committed by the convict. It was against, the acts of terrorism were against innocent Nigerians who reside in the southeastern states. It is also a terrorism act against Nigeria, whereby nobody felt safe and secure in Nigeria, having regards to the activities of IPOB and ESN. The court is urged to note that the company has shown neither remorse nor penitence for the innocent Nigerians who died as a result of his directives and incitements. He has demonstrated no respect for the administration of justice. His conduct, even within the court, has been marked by arrogance and a heart far removed from humility. When he was going out, he looked at me and said, God will bless me. It won't say God will punish me. Say God will bless me. And I say amen. Because I'm a blessed man. It is not him, a convict, who can now put a curse on me. He cannot do that. So in any event, my Lord, I'm not being personal, but I want to assure you that somebody in that position ought to show some penitence, ought to show some remorse, ought to throw away arrogance and self-serving attitudes. The court is further urged to take judicial notice of the fact that the convict established Radio Biafra, a broadcasting platform operating on several digital channels, including mobile radio, Twitter, YouTube, Facebook, WhatsApp, blogs, and Instagram. It is a station with global reach. Evidence before the court, my Lord, shows that when the convict was arrested on 15 October 2015 at the Tulip Hotel in Lagos, he was found in possession of broadcasting equipment. The conduct of the defendant through online publications, live broadcasts, and social media communications constitute act of incitement, encouragement, and provocation of terrorism as defined under the Act. It is the view of the prosecution, my Lord, that without the instrumentality of the internet and social media platforms, the magnitude of destruction, division, and human losses recorded in southeastern states of Nigeria, including Lagos, would not have reached the level it attained. The digital platform becomes tools in the hand of the convict, tools of radicalism, ethnic hostility, and incitement to terror. Their amplified reach resulted in a coordinated transnational militarism or militarization of violence and destructions of public property across several states of Nigeria. The court has both the power and the duty to restrict further access to digital media who are committed by others that prevent the commission of similar or related offenses, including forfeiture, confiscation, or restrictions of the means used to commit the act of terrorism. As a form of preventive control, the prosecution praised this honorable court to impose restriction on the convict's access to digital devices, online accounts, or internet facilities. In other words, my Lord, anywhere he may be kept until his execution in obedience to the sentence, if he has access to these devices, and they are cheap and easy and available everywhere in Nigeria, there will continue to be broadcasts. Maybe he will claim he was not the one. At the moment, if you open to YouTube, you see a lot of rascals talking about the proceedings of the court, trying to twist and mislead the people with what happened in court. So we're asking that your lordship should restrict him from having access to these devices. This honorable court, my lord, has the statutory power to prevent convicts from further committing offenses by making orders for the forfeiture, confiscation, and restriction by any means used for communication. We therefore pray that the court to order the forfeiture of all the broadcasting equipment, digital devices, and all electronic materials seized from the convict and currently in the custody of the Department of State Security, State Service. In particular, the radio transmitter, Trans 50L, unlawfully imported into the country, should be forfeited to the federal government of Nigeria. My lord, we want to say, sir, with all respect, that it might be argued that access to information, access to digital devices may be argued within the constitutional rights but it's not absolute. So therefore, sir, if your lordships want to order his restriction, your lordship may give him a right to acquire any, but with the permission, with the authority of National Security Advisor and the Controller General of the correctional facility that he may be put. Therefore, my lord, it's not an absolute or free right for him to begin to acquire those digital devices that may encourage him to reenact or to begin to commit the same or similar offense under his right freedom of speech. So we are saying, my lord, that your lordship should restrict it. My lord, considering that the company has to be in a custodial facility, we are asking your lordship to direct that for the safety of the convict, for his safety, for his security, and for the protection of his life until your sentence, I respectfully, sir, as prosecutor, plead with your lordship to direct that he be kept in the safest custodial center in Nigeria, because his safety is very important. Your lordship need to take judicial notice of what happened when Simon Ekpa was sentenced in Finland. There were lots and lots and lots and lots of talks and talks. The convict has enemies. He has friends. But no one can say the volume or the number of his enemies who may want to eliminate him. So we are asking, my lord, that your lordship order the government of the Federal Republic of Nigeria to keep him in the safest custodial center anywhere in Nigeria. You know, and if I may say with all sincerity, I am not too sure that Kuje, where there have been jailbreaks, will be the ideal place. So I'm urging your lordship with all sense of responsibility to preserve his life until he answers his sentence. So I thank your lordship, and I pray that the incidents of terrorism will from north to east to northwest to north central, and as we see, may God spare Nigeria of disintegration. I want to thank you. I want to appreciate you on behalf of my colleague Adebayo Ojo and Suraj Saida. We're grateful to your lordship for a well-researched, a well-reasoned, and a courageous judgment. Thank you, my lord.
So waiting remain a sentence.
There is no doubt that the convict has waived his right to be present through his unruly attitude, the habitual unruly attitude to be in court when the judgment was read. But we must still give him opportunity to hear one or two things from him, but not personal, through his person. Since his consultant is here and the offense has to do with death sentence, I will call his consultant, that was his lawyer before he converted to consultant, if he has any allocutors to make on his behalf. Mr. Ejimako, do you have any allocutors to make on his behalf?
My lord, being an officer in this temple of justice, properly dressed, and not being his counsel of record, I will yield this very task to Honorable Obinna Agocha, who is better qualified than me being the member of House of Representatives who represents Mazen Nnamdi Kanu.
It's okay. Honorable, let me have your full name and restrict yourself to allocutors. Allocutors is what will mitigate the sentence. Is our brother. Let us consider, let us hear you. You tell us your name. We can't, because of your ruling behavior, deprive him of allocutors.
Allocutors.
Can I hear from you?
Thank you, my Lord.
Allocutors.
My name is Right Honorable Obi Agocha. And the good people of Iguano, Umuahia North and Umuahia South Federal Constituency in the 10th National Assembly. My Lord, I am the direct representative of Mazen Nnamdi Kanu. That's why you see me here almost every time, showing presence and also showing with him. The matter has come to a closure for now. I'm not his lawyer. I wouldn't know whether they will seek appeal. But for now, my Lord, he's my brother. He's my friend. I went to school with him. We attended primary and secondary school together, though he was my junior. But it is my responsibility and obligation as a member of the National Assembly to represent him as well. My Lord, I plead for mercy, I plead for clemency, and I appeal for peace and for stability of not just the Southeast, but as well as Nigeria. Like the prosecutor said, Nigeria is bleeding over the last few days, and we must bring some of these issues to bear and to understand how to find common solutions to our common problem of terrorism. I also wish to appeal to the prosecution team that it has been done to Mazen Nnamdi Kanu. The other people out there also doing more worse than him.
Please,
sorry, sir.
I asked for a locutor.
Yes, sir.
Please don't.
So, I apologize, sir. So I want the court to take judicial notice of that this trial has gone on for almost 10 years. Mazen Kanu is almost 56 or 57 years old now. He has been absent in his family life, his children, his community, his family. So I plead for the Lord to show mercy, to temper justice with mercy. And as we move, it shall be great for our country. Thank you very much for the opportunity. I'm a friend of the court, having come from the other side of the government. So thank you for giving me the opportunity to address the court. Thank you, sir.
Thank you. I will consider all this, and I will rise and come back by 10 minutes to 4. You may go and come back 10 minutes to 4.
For the judgment.
Sentencing.
For the sentence.
I will rise and come back.
Wow. People, I don't know what you think. You have read, you have heard what, I think it's better to into this now. Okay, so you have heard what the prosecutor is requesting. The prosecutor is requesting. Okay, let me give you a recap. As a result of as a result of an altercation between Mazen Nnamdi Kanu and the trial judge, the judge walked him out because he started pointing at him, in his words, according to the judge, making unruly remarks, and he was asked to leave the court. Okay, he was asked to leave the court. Now, As a result of this, he read out all the charges. That was 7-count charges. And in these 7-count charges, Justice Omotosho has convicted Nnamdi Kanu in all the 7-count charges, 7 terrorism-related charges. Now, on count 1, 2, 4, 5, and 6, these are death sentences. Basically, it's a death sentence. Basically, right? 1, 2, 4, 5, and 6. On count 3, it carries 20 years imprisonment. Then on count 5 years imprisonment for count 7, right? So looking at this, the prosecutor is now making made a submission that he should be on count 1, 2, 4, 5, and 6 as the as the law prescribes that Nnamdi Kanu should be given death sentence. Now, on count 3, that he should be given 20 years imprisonment, and on count 7, he should be given 5 years imprisonment on count 7. So if we put all this together, and I read what people are saying there, in the comment section, and the judge also made very clear that I think while he was reading count 2, 3, that he gave him enough time to get a defense lawyer after he fired all his defense team. And at the beginning, I said, while I'm shocked, I never expected that we will be getting to the point of the question of death penalty. But one thing is very clear, that it is very likely that I don't know. It's very likely that the judge may agree with the prosecution team. You know why I said this? If you pay attention, all the counts that the prosecution team presented, argued, the judge gave, basically agreed with the prosecution team. Now, in judgment, if you agreed within the trial, in judgment, I do not see any room for wiggle or maneuver. Even when allocutors was given recent now to barrister Ejimako and his House of Rep, Ejimako yielded to the House of Rep, who made a plea for the judge to tamper justice with mercy. So we are going to see that justice being tampered with mercy, hopefully in the next 1 hour, because that's when that's when they resume, in the next 1 hour, right? So we will see 10 minutes to 4, then we'll come back. But at that, I don't know what you think, and I'm going to do this. We may have to wait, stay here if you guys want, or we go and come back. So let me take your, how are you feeling? Because for now, I don't know how I'm feeling, because, I didn't expect this. I'd already, by 6 o'clock, I'll have, I see if his lawyer, I'd already reached out to Maxwell to join me. Maxwell Opera to join me, and I already reached out to other lawyers as well. So we'll be having a program by 6 p.m. And I think the team are trying to set the live stream so that it's going to be easier. And you guys will see when the live stream is up here and to join. So this, life imprisonment. Now, it also if I stay with Nnamdi Kanu's case, then the question that would actually come to my mind, remember that I think yesterday or day before yesterday, one of the Boko Haram terrorist leader was sentenced for 20 years imprisonment. So I haven't read the details of that judgment, but for life imprisonment and death sentence for a case that is argued to be the same. One took active participation, the other one was through audio messages and visuals to incite for certain thing, for the unaliving of people to happen. So either way, people died, no matter how you look at it. Either way, people died. So the question is, is it then fair? Then I'll ask, in all this and beyond this, our conversation earlier today will center around what happens next, right? If you ask me, I think this judgment is for a reason. The government wants to do the following. One, send clear signal and message to anyone who is wanting to follow this path that we are not going to tolerate any more nonsense. Many have argued to me in private that as a result of Owazirike's case, going through a political process is the reason why the second phase of the agitation got to the level where it got. Why so many have also argued that the failure of the previous government to prosecute people like Asari Dokubo, Ateke Tom, and Tombolo, it's also because in their argument, the school of thought that if these individuals were prosecuted and jailed or not jailed, convicted, right? That if they were convicted and probably eventually as a political negotiation tool and granted bail, certain things may have ceased that you will not see next generation carrying out with that. So if you ask me, I think this is what the government is trying to do, to send a clear message, be it north, south, east, west, we're not going to tolerate this, so you better stop. Now, and in stopping that, it then means a greater consequence, in my understanding, for those who now identify as IPOP member, especially those of you in the diaspora, United States of America, UK, and many countries in Europe, that by this by this sentencing today, or rather by these judgments today, that it is going to be very clear that these countries are going to be told that Nigeria is reaffirming that IPOB is a terrorist organization. And by that reaffirmation, it has dire consequences to you watching me now, if you are a member. Depending on your job, many of you work in places where you need high level security clearance. You got to be very careful because that can affect your job. If you're a nurse, that could also affect your job. There are some jobs, especially within the IT, where you need access to clients' data. It can affect your job. So at this point, caution is demanded. The choice is yours. Especially, you can also pray that the government stops here. If the government ever demands that those who have contributed monies to fund the ESN, if they ever demand that they prosecute them, that means you might be innocent, but you may have aided I'm not saying, this is in the context of what has been decided today. It's not my judgment. I have no opinion. I'm just trying to look at it dispassionately. Having said that, in the comment section is the link for you to join me here while I take some of your comments. Demian Ibazu said, let me take some of your comments here. I don't. Damien says, Mazik prosecution now can't solve the problems. Rather, the social justice will heal the wounds of the agitation. Of course, there's never a time anyone would argue that this prosecution would solve the issues. But even the issue of agitation and marginalization, as many do cry foul, again, it depends on where you're standing, right? Some have argued that in most cases it's not the issue, but again, that's a story for another day. We will keep, we may come back to that, but it is quite instructive that even the decision or this prosecution, the date coincides with a time that there is a heightened tension in Nigeria with the Christian genocide happening in the Middle Belt and some parts of northern Nigeria. If you look at the one that happened in Kwara in a church where certain individuals marched in a church, story has it that three people died and the pastor was kidnapped and a couple of others. You see the old woman on a blue wrapper that really, I think anybody with any atom of sense in them would really be broken by that video, looking at that mama trying to run and she couldn't. And that broke me because I'm like, this is just a mother who has just gone to church to pray. Her crime is coming from this part of the world, right? Looking at the fact that Donald Trump had made the statement he made on the Truth Social, which was reposted on X, and the actions by the Nigerian government telling them, "Oh, we are doing all our best, doing this too." So you can also understand that the Nigerian government would want to do anything to say, "Okay, we are not terrorist enablers." But in all, my prediction is this sentence might stand according to what the prosecution team is arguing. But for those of you who, especially those of you who are from the Southeast, I can certainly guarantee that there will be a political solution to this. But for that political solution to come, sometimes some of us are quick in this keyboard to write and insult people. I had a program here when I said, if we are paying attention, listen to what Bola Ahmed Tinubu said, and listen to what Senator Ojus Okalu, who is very close to Tinubu, what he has said. Recall there was a time that Ojus Okalu mentioned that he was going to. Temia, I've seen you. I'll let you in shortly. Recall there was a time Ojus Okalu mentioned that he had seen Tinubu and they would discuss about this. Eventually, time passed. And the last time that he was asked, Ojus Okalu said that he is not going to comment on something that is before the court. Again, if you take a back seat, recall that when Nnamdi Kanu was arrested the first time, and when it came to the perfection of his bail, not many of you know the role played by the former former DSP, Deputy Senate President Ike Ekweremadu, who is now in jail in the United Kingdom. Ike Ekweremadu eventually got a beating of his life in Germany, but he played a pivotal role in ensuring that Nnamdi Kanu came out then. If you then backtrack a little bit, you now begin to understand that in all these things that is happening, there is something that the government wants to do in all this. Government, like I said before, I can guarantee you there will be a political solution where Nnamdi Kanu will be released will be pardoned. Because the tension, the noise and the tension, this judgment and the sentencing will send across Nigeria will be deafening. Right? So, irrespective of the fact whether he will be pardoned or not, there are still consequences for those of you, especially I can't warn you guys enough. You may insult me, but I can't warn you enough, especially those of you in the diaspora. The consequences, because you may not have the resources to go to court and start defending yourself, because these nations will act based on rulings from Nigeria that this entity is classified as the, because with this you can no longer go to court, in any court in Europe, and say I do not belong to any group that is classified as a terrorist group. No, you can no longer, because in the country of operation it has been designated, gazetted, and by those designation and gazettes that they got, the court today relied on it to now say on count 2 that this is so. Therefore, when they review that in any court anywhere across the world, they will say, well, I mean, based on this, recall that even when the judge talked about extraordinary rendition, he mentioned a case in America, someone who was illegally abducted, but he faced judgment in America. So, citing that, in as much as that extraordinary rendition is illegal, Mazi, you have never lived in the US, and that's why you're saying, well, I'm not in the US. I don't live in the US. But Pansat, the only thing I can tell you is be careful. In Igbo, we say, Atwalo malo malo, atwalo feke. Ofenyi isi n'ọhịa. If you know, you know. Right? If you know, you know. Watch yourself. Ignore whatever Pansat is saying, please. If you live in Europe, I'm begging you, pay attention. If you live in Europe, I am begging you, pay attention. Ignore this. I don't live in America. I've never said I lived in America. But I can tell you this. With this, what has happened today, with the conviction of Simon Ekpa, come on. I guess do you want it to be drawn or what? You guys should, we should be smart, right? You put one-on-one together. You may not like it. I may not like the outcome. But it's not about what we feel, what we like at this point in time, right? It is about what could be of, what could affect you somewhat. And this may affect you. If you think it means nothing, then of course, I mean, when it affects, not be me and you, it's you. But I'm just telling you what I think. I might be wrong, but I don't think so. What I think could be the consequences of what has happened today. Yeah? Well, I'm as speaking as a Anambra politician. Okay. What do I know? I won't say more than that again. So, if, like I said, if you want to air your view, if you're not a keyboard warrior, you want to show your face show, right? Come online and let's have this conversation. Powerful Saddam Hussein of Iraq, who could eat Tinubu for lunch, was dismantled by Iraq's American diaspora. I don't know what that means. Okay, King Boy, I have no say. He says, Oga, we will continue to contribute for our freedom and can't scare anybody. Okay, good luck with that. Go ahead and do your thing. We shall see. Well, right now the spotlight is coming from the US and the evil government, and you know what everybody's asking. I hope you guys are aware, and I hope you know the implication. When the government is saying that there is no Christian genocide, that the Christians are not being, there is no genocide being committed against Christians, right? That's what the government is saying. and the same government. Oh, Rudy. Rudy.
Yeah, man.
I am fearful. Oh, your name was mentioned when the judgment was being read, and I said, you are. I hope you have not. You haven't entered trouble. Hmm? Rudolph, are you there?
Yeah, I'm here. I'm here. I'm trying to. There's an echo. Yeah, man.
Okay. So, I mean, I say your name was mentioned, though. I chuckled and I said, now so Rudolph take enter trouble for waiting in honor. Hmm?
It's been. I've been getting calls from everywhere. Yeah, you can hear me.
Yeah, I can hear you. Go ahead.
So I've been getting calls from everywhere.
What's the call about? Are people scared of? Oh, I mean, what's?
Yeah.
Anyway, now, I was saying, Rudolph, but I think a lot of people who joined didn't, or who are commenting, don't understand it, or because I was saying before you joined that my brother Frank Onero, you're welcome. I was saying to some of the people here that I think by this judgment today, the federal government has kind of tripled the affirmation. Okay, yeah, hello.
Yeah, hello.
Frank Onero. Yeah, okay, go ahead. What's
yeah, Adeo.
Yes, I say, what's your take on the judgment today?
Well, I never expected anything less. I don't. I never expected anything less. Like you said, even before now, me, I'm from the Niger Delta, right? And then I did not personally, my personal opinion, I'm not a fan of unnecessary pain and buying of our people, whether in the southeast, in the south, in the north, and any part of Nigeria. Right? But in all fairness to Nnamdi Kanu, in all fairness to him, what is going on in the north for the purpose of disclosure? I was born in the north. I didn't grow up in the north, but I lived among the northerners in Delta State. I grew among them. I understand their kind of mindset and their orientation, especially when it comes to religion. When it comes to religion, that is like blood flowing through their vein. They care less about any other thing. For the majority of them, some, maybe because of education, they may have changed. If you compare what is happening and what we see, let's say in the past 10 years, that's going on in Nigeria with Boko Haram, ISWAP, La Korowa, or whatever the new one is, and many more. And the way the Nigerian government, as a government, have been treating this category of people, you will say, in all fairness, Nnamdi Kanu should not be in this circumstance. That is not to exonerate some of his incitement. I used to listen to him. Let me not say I used to listen to him. I somehow come across some of the videos before that NSAS protest. You know, when I come across it, I'm like, this is not going to end well. It's not going to end well. But of course, many of our people, they are diehard supporters. You know, they do all the things they want to do. But I want to align with your thought that this is a game by the political class, both the current failed APC government, that according to one of their own person, imported terrorists to Nigeria, terrorists, camped them in bushes, expecting that Goodluck Ebele Jonathan will not, as a matter of fact, relinquish the presidency in 2015. But Goodluck said, no single blood of any Nigerian will what his ambition. And the man, before election was declared, he said, make una carry the presidency go. He does not want this to happen. But,
go ahead.
But these people refuse to send the people they brought in from different countries across Africa to cause mayhem in case Goodluck did not go. They are the ones terrorizing Nigeria. Carrying, everybody seen the videos of local government chairmen, state government, in whether Katsina State in particular, trying to negotiate, settle with bandits, terrorists, killers. And you now tell me, I was listening to the judgment that they found radio transmitter. What is the comparison of radio transmitter to the weapons of mass destructions that we see that these terrorists and bandits are using to terrorize our fellow citizens across the northern cities in Nigeria, in Katsina State, in Kaduna State, in Zamfara State, in Nasarawa State, in Plateau State, in Benue State? What has the government done? Not to arrest them, to just stop it. But they said they found a radio transmitter. That radio transmitter should be seized. Radio transmitter compared to weapon of mass destructions, AK-47. What is the comparison, my brother? In all fairness to Nnamdi Kanu. To me, some of his statements in some of the broadcasts were inciting. Of course, they were. Absolutely. I agree with that. But for me, it does not amount to terrorism for him in particular. That's my opinion. It may be inciting. You know, Nigerian law may be different from the laws that apply in America. Of course, in America, they have freedom of speech. You know, where I currently reside. You know, because of all those shenanigans in 2014, 2015, that was when I made my decision. I said, no, I don't think I want to live like this in this kind of environment and this kind of mindset of our leaders especially. I thought it was going to be better. It's getting worse and worse and worse and worse and worse by every day. So let's boil it down. There will be, this is a game from both the current government, some of the leaders in the southeastern states of Nigeria. They see Nnamdi Kanu as a threat to their political career.
But they have jointly asked the government for a political solution. They have multiple times, and some of the governors on individual times, especially the APC ones, have on multiple occasions requested for a political solution.
They are not genuine.
Well, it's not. No, well, what do you mean by it? It's not the decision. They can only request. The question is, before you joined, I was given an analysis of what Oji Zokalo said and what the president said, that the matter is in court, where, in my view, alluding to, even if I'm going to go for a political solution, I will allow the court to finish their process before I can come in. And I am of the opinion that I can certainly bet on this, actually. I'm willing to bet any amount that there will be a pardon. That I can say. But again, one thing I think why this case has gone the way it has gone is that the government want to send a message that, to curtail incitement. Recall, there is a man in the United Kingdom called Adeyinka grandson. The British government jailed him for 3 years. The reason why that happened is that, and he was there inciting, making public incitement from the United Kingdom against Igbos and Fulanese in the southwest, especially Lagos and Ibadan. And the British government jailed him. So sometimes, in this sense, I think it's for further occurrence. Probably that's what they are afraid of and trying to stop, right? Like, I don't know if you really understood when Wazirike was.
I do. I do.
Hold on. And then the Wazirike eventually, through Senator Uche Chukwumerije, he led the caucus that got him during Obasanjo, a political solution, discontinued his trial, right?
Mm-hmm.
So now, and the scenario quite slightly different, but not much, right? So if, as I said before, there are some school of thought who believe that if Wazirike was prosecuted to the end then, and eventually convicted and given pardon, that you may not see the level of what that is happening now, or that happened now. Now, again, that is on that plank. But let me come to what you said. You said, what they do in the North. Let me tell you, I said this 3-4 years ago, and some of my brothers got angry. There is former Commissioner of Information in Adamawa State, Sajo. In one of the interviews I had with him during COVID lockdown, he said to me, Mazi, whatever you guys do in the Southeast, please do not allow the military to enter the Southeast. I said, why? I said, because when they do, innocent people will lose their life because they don't know, from the way they operate. And eventually, that which Sajo warned happened in the Southeast. Both guilty and non-guilty lost life, right? Mm-hmm. So if we just oppose all these things to your, like I said, to your argument, you begin to see that at the end of the day, he's going to get a political pardon, but how do you then mitigate that such a thing doesn't happen? There are people now in Anambra State, for instance, since the last 5 years, they have not been to their ancestral homes. And the reason why they have not been to their ancestral homes is not because of anybody from the north, as it's easily said, the Fulanese or whatever. It's not. It's about, just like what Professor Soludo said in America the other time, and people got angry. It's about us, right? So people who actually misconstrue some of the statements and now went an overdrive on some of the actions that eventually brought us here. It is a sad, honestly, it is for many people of the Southeast, it is a sad day for the Southeast. But again, beyond that, the question that must then be in the minds of many people from the Southeast is, where do you go from here? And if you ask me,
that's where I'm going to drive up next, where you are, if you allow me to come in.
Yeah. So where do we go from here? That is the point. And I think, the judgment has some, you may call it, mitigating factors or elements to it, But we can't continue like this. And I land with this before I allow you to say that is, when we make certain comparisons, I don't like it as a person. Oh, well, they do this, the other person, they do that. Your wife has given birth to an imbecile who behaves in a certain manner doesn't mean I might have to go and impregnate my wife to give birth to an imbecile too. That you have a madman in your house doesn't mean I need to create one. It's not do you understand? You know, before now, the Southeast had been, irrespective of what is happening in Nigeria, people flying in from all over the world and come to the Southeast and enjoy. But we cannot boast of the same thing now. But again, this is not the day for this conversation. But what next is the question that must, detain the attention of every single individual now. So what do you think happens next?
Oh, okay, thank you for giving me the opportunity to come in at this point. For me, when I was doing my master's program, right, I was taught a particular course. It's called behavioral sciences. Human being, their mindset is different at different time and based on different circumstances or events would drive that person's mindset to act. Ojus Okalu, I'm not a fan of Ojus Okalu. I'm not, because most time the way those people, they chop our money, thief our money. Ojus Okalu was convicted. He was later pardoned. My state governor was also convicted. Former state governor. I'm not a supporter of, I supported him when he was initially governor. But when he thief our collective resources, I rule you out. You know, Ojus Okalu, who is very genuine, I will take him. I'm not a fan of him, but he's genuine in trying his best politically to see if there's a solution. I can agree with you. But many others, they may just say for some, at that moment, they don't push it. They don't. That's the truth. Then you talk of the way forward. The way forward, I will drive at that. But I want to address one or two things that you mentioned. Nigeria, as a country, has not treated citizens from certain sections of this country fairly. They've not. I will give you different examples to tell you they've never been fair. Even when you are one of the best. Yes, when I was to get into the university, I wrote JAM many years ago in the mid-90s. Yes, I wrote JAM. I passed. I got over 200. But to get admission, it was a battle. If you from Delta State, from Enugu State, from Anambra State, from state in the Southwest, you must score 240, 230, 250 to get admission to study engineering, which I did. Or to study medicine. They put the cutoff at 270. But if you are from Zamfara, they will admit you to study medicine and engineering where you get 170. Is that fairness? That is not. They call them educationally less developed states. That is the language they use in the JAM brochure then. I cannot forget that because I studied it. That's not fairness. Then after we graduate, in trying to get a job, if you apply for NNPC, if your name is Musa, they will give you priority. If your name is Mohammed, they give you priority. You have to fight if you are from any other state. You have to battle. One of my classmates had to change his name. Had to change his state of origin. He's from Edo State, but he answered like an Hausa name. But he has to change his state of origin to be able to get a job in NNPC. At the end, they still fired him from what I learned. My classmate, we graduated together. So I'm giving you data, information to tell you that the country have refused fairness. They have chosen favoritism, tribalism, religion above competence and qualification. You understand? So to tell me that we should not compare will be unfair to some of us that feel, that have experienced those kind of I won't say marginalization, because most of us fought through it. We saw it as a challenge to overcome it. So that is the system that has been set up in Nigeria. So if justice must be done, justice must be seen to be fair to all. If you apply this to Nnamdi Kanu, this same must be applied immediately to Tunji Bello in Zamfara State. That is terrorizing, lying, unaliving our fellow Nigerians.
No. Calm down, my brother. You see, when we make certain comparisons, we have to be very careful. Now, we are talking about is Tunji Bello, is he captured? Is he in custody?
Why have they not captured it if they are able to go to Kenya to capture Nnamdi Kanu?
Listen, there are comparisons that are probably not right sometimes. Hold on. I said this. As we are talking, some part of the north and the level of mess that goes on there is mind-boggling. But you're also aware that the level of bombing that happens there, I would never wish that to be, I would never wish to be in that neighborhood, because it is also, kind of serious matter, right? So if you rest assured, there was a time Abubakar Shakau was making videos threatening everybody, but eventually he was taken out.
Not by Nigerian government.
I don't care who takes him out.
Shakau, we have to be clear on that.
No, hold on. Shakau was taken out, right? So again, the Tunji Bello or whatever he is, if you want, I bet you very soon, sooner or later, he will be taken out. Listen, there is a part that no matter what, no matter your anger, there is a part that I would tell anybody, I wouldn't take it and I wouldn't encourage you to, because it has only one outcome, and that is death. So if somebody is in the north, Allah Akbar, and he's trying to kill people and do this, it's only going to end in one thing. Either you might end up killing one or two security agents, but be certain that that individual will not live long to tell the story. That is certain. However, that is not the discussion this afternoon. The discussion is what next from Nnamdi Kanu. I think when we come back in the next 20 minutes, no, in the next 30 minutes, I believe, less than it, right? Yeah, in the next 22 minutes, actually. But I need to end this stream to start. I think when we come back in the next 20 minutes, what we are likely to see is that the conviction will happen, right? Sorry, that is the sentencing will happen. And my prediction is that the sentencing might follow the pattern of the argument posited by the prosecution team.
No, I don't think the sentencing will be done today.
No, the sentencing, that's why the judge now said they come
back.
No,
judge said he's going to sign the certified true copy.
No, he said two things. He said he was going to sign the certified true copy of his verdict. Then when the prosecutor finished his statement, now said, put forward what he thinks should be in the sentencing. The judge now said the sentencing is going to be 10 minutes to 4. That is 3:50, right? So that's in the next.
I didn't hear that. Maybe I didn't hear that part.
Well, in the next 20 minutes is the sentencing. So that's why I think probably we'll stop this stream and we'll come back again for that. But like I said, it's quite an emotional day in the Southeast. My advice on and to anyone in the southeast watching me now, please be mindful of your movement. If you ask me, if you are home now, stay home. Don't go anywhere. I'm just being careful because you never know. People might really get upset and anything can happen. So if you're home as you are watching me now in the southeast, I would plead with you, if it's non-essential, especially outer states, if you want to go outside your state as we speak. If you ask me, especially also if you're in the remote areas, not in the capital cities, if it's possible that you do not go anywhere now, please don't. Because emotions are high. People may act in a way that may not be reasonable. Okay. So I'm just saying here, stay safe out there. Right. So, but again, what next? The prosecutor said count 1, 3, 4, 6 is death sentence. I don't think that, I might be wrong, but I don't think that's going to follow here. But even if it does, I can certainly guarantee you that political solution would then happen. And somebody is saying, you see, the funny thing is that people don't even know. They might tell Tinubu that when you do the political solution, you may win the Southeast. So let me not say anything, but that's not true. Will giving Nnamdi Kanu pardon, will it change any political fortune of Tinubu in the Southeast?
Adapt.
But one thing it will do, it might bring more it might bring more peace in the region. Right? Now the question is, mistakes has been made previously. The Southeast must undergo a program of disarming non-state actors. If that is not done, no one is safe. Because, anyway, a conversation for another day. But for now, I think two things. One, the sentencing is going to happen today. And two, he might be taking the advice of the prosecution team. Recall that even the prosecutor said that he showed no remorse. Recall that he was moved out of the court because he was, exchanging words with the judge. So, and a senior lawyer that I was speaking to last night when I wanted him to appear on my program today, when I asked him what he thinks, he was the one that actually, last night was the first time I took notice of the word elocutors. That is when somebody who is about to be sentenced is given the opportunity to say one more thing. And he said, if Nnamdi Kanu doesn't flare up and does very well in the locutors session, then the likelihood that his sentencing from life may be commuted, because the lawyer was so adamant on 1, 2, 4, and 6 that he may then, in this sense, because of his soberness and the way he has spoken, he might then be committed to life. I said, but it doesn't make any. What's the difference? Life and death is the same. But the nomenclature for me doesn't matter, and he agrees, because at the end of the day, irrespective of how you look at it, what matters is what then happens after. This is now where the political machineries will go, because these people, the Southeast leaders that have all now migrated to the APC, the people will now begin to question them. Of what use of you guys migrating to APC, telling us that is the place to be, whereas when it comes to the place to be, you guys are nowhere to be found. So they need now to prove their worth by saying, we have to get this done. Again, I pardon anyone who is even insulting in the comment section, calling people cowards. I mean, what we are doing here is to give you sound analysis, not emotions, right? Is not an act of cowardice, but at the end of the day, You have your ears, you have your data. We appreciate that you're here with us. If you don't mind, I will beg you to like, share, and subscribe, and join us in the next 15 minutes. Thank you very much, Frank Onero. Thank you for joining me. Thank you. And people, thank you very much for watching. I will be back in the next 15 minutes. Let me also take a break. Just watch out for the live stream that has been created for that. Thank you. And God bless us.